recess. We were still in discussion on the Cruz Amendment, and there was a request made by the body for some information and for representatives of the Department of Land Management, if I'm correct. And so my understanding is that those officials are here. So if we can have, please, those individuals come in and then also be sworn in. All right. So let's get it. Let me take a 30-second recess so those guys can get situated, and then we can get moving. Okay, we're back in, and two individuals representing the Department of Land Management have been sworn in. And so, if you can, gentlemen, and you turn on the mic and please introduce yourself and what agency you represent. Right. Okay.
My name is Carlos Aranzalan. I'm from the Department of Land Management, and I'm currently the acting chief planner.
Okay.
My name is Michael James. I'm the acting director for the Department of Land Management.
Okay. So, what be the will of the body? Senator Pangilinan.
Thank you very much, Mr. Chair. Mr. Chair, I just wanted to get the clarification with regards to the presentation yesterday of the amendment and the reference to the actions of the body back in the 23rd, I believe. The original action was back in the 23rd as it relates to lot number 439 and the severance of that lot, and then referencing a map that was that showed the severance of that lot, so that we have 439 and then 439R1. And the map that was presented had under the notes the zoning designation of the lots and so forth. And I wanted to be sure that the action of the body and the way that the amendment was written and the restatement and the reference to the map did not go beyond what the original intention of the body is when it identified that site as being a site for the landfill that was made based upon the recommendation given to the body at that time. So, and the individual's name is good because we have one who's still here from those days. Mr. Carlos Santalan shows your signatures on this property map. Could you just explain the history of that map? I know that was originally from 1968. We were also provided a portion of the Land Use Commission meeting back then referencing these lots. And so can you just give us that history and trace it to where we are at today with those lots?
All right, Senator. That question was already posed during my testimony before the... Yes. It's on. Can you hear me? Okay. That question was already posed during my testimony before the Guam EPA Board of Directors. But here's, and if I be allowed to read our response at that time, it was actually a response to Calvo and Clark concerning the zoning designation of the subject property in question. And I'll read a portion of that because it relates to Senator Pangilinan's question on the chronology of the partial itself. Okay. The Territorial Planning Commission approved the zone change from A to M2 on August 15, 1968, as shown on Amendment Number 2 to the zoning map, and I'll quote, the zoning map number is F3 67S50 under document number 87691. Upon review of that amendment map number 2, as I had mentioned, it shows lot 439-1. That's the portion of the Gorco. The basic lot back in 1968 was actually basic lot 439 itself. But on the zoning amendment map, it was shown on the Gorco's interest, lot 439-1, which is the subject of the rezoning at that time back in 68. It did show on the zoning map the actual outline of that portion of the basic lot. It was anticipated that the portion of the Gorco lot was to be 439-1, and that's why you see it shown on the zoning amendment map. At that time,
Do you have a copy of that?
yes, I do.
Okay, maybe if we could.
And these are my files from the testimony from before the GIPA board. But in going on, the reason why that 439-1 was shown, even though it was actually not partial at that time back in 1968, was that the map was also being prepared at the same time as a land registration proceeding that was undergoing for the Gorco portion. But everything else, everything that has been shown is shown as 439-1, and it's been shown that only a portion of that basic lot was to be rezoned from A to to M2. We also look at the minutes of the Territorial Planning Commission at that time, and the minutes of the special meeting of August 15, 1968 specifically records the subject lot of the rezoning as basic lot 439 was not subdivided. But it mentions on that TPC meeting that only a portion of basic lot 439 was to be rezoned, and it qualified it by the portion for Gorco and nothing else on the entire basic lot. So that's the chronology of the rezoning of that basic lot 439. Our position and our records indicate that only the Gorco portion, which is basic lot 439-1, is zoned from agriculture to M2. All the other portions of the remaining basic lot, which we now know as 439-R1, which in current maps is showing that lot number, and also a qualification as partial B and partial A as well. That portion is currently zoned agriculture. Now, getting back to the map itself, and I refer to map number 274 FY 2001. Okay, and if you would note on the right column, there's a vicinity map right at the top, followed by legend, and followed by notes. And I'm referring to note number 4. I'll read what it says currently on the map. It says subject lots are zoned M1 in parentheses, in quotation, comma, heavy industrial, residential as approval of this map. First of all, what I would like to clarify is this is a survey map and not a zoning map. So, and that notes is just really an explanation of some of the things that may be ongoing at that time. Notwithstanding that, that note number 4 is contradictory in itself as well, because the zoning district, which they followed, which is the first one in quotation, which is M1, followed by heavy industrial, thus it contradicts each other. The proper zoning designation, if you were to use M1, would be light industrial, and you wouldn't even have the additional wording residential. So note number 4 is contradictory in itself to begin with. And then, of course, that is an error as well, because all of our official zoning records, which I referenced earlier, which is amendment number 2, is the official zoning designation for the not only for lot 439-1, but also for the remainder of those adjacent lots as well. Now, in reference to the map itself, and I refer to it as a property map, not a zoning map. And the question may come up, well, can that be changed? The answer is yes, but got to remember this product is not a product of the Department of Land Management. It's a product of a private land surveyor, and I don't have the uh, the Title 18 with me, so I can't cite the section, the proper section, but it's found under Chapter 3, I believe, under the Uniform Triangulation System. That once a map is done by a private land surveyor, we could not change that. The only one that can change the map to correct it is the private land surveyor himself. Even if we tell him and he stands on his professional opinion that it's correct according to him, we can't change it. Only the professional land surveyor can change what's shown on the map that he has prepared.
But wouldn't that Title 3 be reference to points and boundaries and not notes and legends?
Actually, if you read Title 18 under Uniform Triangulation System, it gives the rules and regs of map preparations to a certain extent. It does show that you can add additional notes to explain the map itself, and it does have a provision that once the map is prepared, it cannot be altered unless it's revised. And the only way to revise this map, to correct it, is notification to the surveyor to come in and revise the map.
So when you sign the map, are you signing it as to accuracy or as to
No,
receipt or?
Well, first of all, if you look at my signature block, let me qualify. The survey of this map, the title survey of this map is a retracement map. Okay, if you refer again back to Title 18 and you look under Chapter 3, which is the subdivision rules and regulation, my role in the planning side is really, or the required signatures on it is really not required of that for the chief planner itself. And if you look at this further, I'm not an approving authority. It's just a check by from a land management staff, which I was at that time back in 2001. But primarily, the bulk of this, the most important part of this, is the plat itself. Because if the plat is wrong, then your deeds are wrong. Yeah, and of course, the other data there is just a nice to have data that you can fall back on, so to speak. But if I were the individual and I looked at that, I would verify that with the department to see if that zoning is still current or is in error. In other words, I wouldn't really totally put real good bank. I wouldn't bank on it, so to speak. I would verify it.
Let me ask, I guess, a further question then. The map was, the parcel was subsequently divided to Parcel A and Parcel B of the 439R1, the remaining lot after the severance from the 439-1, which is the Gorco. Gorco was severed.
Right.
Then 439R1 remained, is the remaining lot number designation, and then further severed or parceled to A and B. Is that correct?
That's not correct.
That's
No.
not correct.
Yeah. Well, what you find here is the actual retracement of 439-R1 that legally still exists as of this date. If you look at the map itself, it just shows you a delineation of which portion is partial A and partial B within that 439-R1.
So
it's not a severance.
So it's what is not severed at all.
No.
Okay. So when the when the reference now is to that there was a law at one time that still exists today that authorizes and designates that authorizes the placement or the construction of a landfill within the Gotali site, how do you decide where it goes and what's the, I guess, what is Gotali in this case? Is what we're trying to reference here Gotali, or is it no longer Gotali as it relates to Public Law 23-95?
I don't think I could answer that quite clearly. Yeah, and I don't recall the exact sections of the law itself. I'm familiar with the law in general. But in terms of if the law references Guatali and if it identifies a specific location, whether it's partial A or partial B, I don't recall it.
I don't think it does. And we could, if I could just ask legal counsel to pull that up real quick, maybe we can see exactly what it says. I think it's Public Law 2395.
The partial A, I believe, is according to the map here that is shown. It's owned by I guess the U.S. Department of
National Park Service.
National Park Service.
Okay.
And if you look at the delineation, and this is the reason why they probably delineated as partial A and B, is to show where the interests of the local government of Guam, and the interests of the Parks and Service.
Okay, yes.
Yes.
Now, so partial B is what we're talking about.
I believe
because we no longer control partial A.
That is correct.
And, we couldn't put a landfill there. So is partial B Guatali or is it not Guatali?
My understanding, it's not. I think Guatali is north of the subject lot.
It's north of the subject lot.
Yes.
Okay.
That's my understanding. Yeah.
All right. How do you come to that understanding?
Well, if you look at the maps, and it's not shown on this map here, other maps, it shows this as the Atantano side. Atantano River, right. And so this is the Atantano portion of it.
So rivers are usually at times
the place name, right.
Place name used for delineation.
Yes, right.
And Guatali is
not
north.
On this side, right.
Okay.
It's north of the subject property here,
Partial B.
which is partial, to the north of partial A, I believe.
Right.
Right.
Okay. Thank you. So, again, the conclusion would be that when the legislature passed that, whether we knew it or not at that time, and we just reference it to the place name, parcel B is not within that place name designation.
That would be correct.
Okay, thank you.
Okay. Are there any more questions? Okay, all these gentlemen. Senator Shimzo, Mr. Vice Speaker.
Thank you. I thought we were going to get a copy of the per Senator Pangalin's request of 2395 to see.
I think that although he did request for it, there was through the line of questioning. My understanding, let's check, Senator Pangolin, you requested legal counsel to pull up 2395. Was there a reason?
No, I think with the questions and the responses from Mr. Antalan, I'm satisfied with regards to.
No, okay.
Yeah.
Yeah, okay. Then following up on that is that these are names of, like, for example, just in Agana, we have so many, I don't know, did they call it barrios or barrios? Or, they have like in Inalahan, we have Maiti, we have Pekka, we have Salamilagro, Malolo. It's all part of that municipality of Inalahan. Is there a map of traditional boundaries of, like I said, Mighty? The people know generally. In fact, you can probably be standing in one area and then it's Mighty, let's say, and then it's Mongmong, and then even up here, Apugan. Do we have a something like that he shows the historical? I guess, are they called barrios or
Actually, they're called place names. There's a place name map that I recall that I could probably provide. I don't have it with me here,
yeah.
but if the request is to give you a copy, then sure.
Yeah, and the reason why I asked that question, because on Public Law 2395, prior to the 23rd, I was in the 22nd and the 21st when all of this was being done in 4 years to come up to a selection of a site. And at that time it was Public Works and EPA. Senator Nelson was on the Public Works side of the House. I was on the EPA side of the House. And then the group that went out to look for the site, I think they had about 14 different places. Of course, I didn't return to the 23rd. So the construction of the language that used the word Watali and Malaa, when that came through, I said it's as a result of what was presented on the 22nd and the work done on the 21st on up. Then they enacted the legislation that the municipal waste that formerly known as the dump, but the incinerator and so forth, the integrated system was going to be in Guatali and Malaa, and I'm wondering. The experts, when they say, you code it in, if you do English, name place, and how far away is the name place of Guatali to what this partial that we're talking? I mean, how far is it? And I bet you, in between that, there's other names. In between that, just like here in Aganya, there's so many. Santa Cruz, no? I don't know if there's Santa Ana or whatever, and so forth. But how far is that Guatali? Because I tell you, if what you're saying is correct, and this is the reference that's being offered as the site, Timampotsu, o Komashat Gana istinay. I'm wondering if you had that, then maybe I can really say Hungan Matan Natantano, Pasofag Ifionia, Pasop, I mean, sometimes there's a general area, just like here in Agatnya. It's a general area, and you have all those little barrios, right? And I mean, like we say, Aganya High is Tapagotatan, Gagi Gulo Luke Apugan. Didigi. So all of this nameplates, I'm wondering, before I jump to the conclusion that the expert at that time weren't Timampotsune and came up with this map and led everybody to believe, even the lawmakers at the time, that this is the place called Guatali, only to find out 13, 14, 15 years later that Guatali is further up north. So I'm wondering, is 439.R1, because it's north, is that where Guatali would be?
That is my understanding.
Yeah.
I could be wrong, but that's my understanding. But what I can do is, when I get back to the office, I can take out the place name map.
Yeah, because if you look at this, what Senator Cruz, the map that he provided here, and of course the notes, that needs to be, if it's to be corrected by the person who wrote the note, you're not in that position to do that, of course. So if the north, I can think that it's up here. Could it be that 439 northern part could be just the part that says, Guatali knows Malaa, that north up here?
Right.
Could it be? And then when they did that, they just pinalaya todo papa na.
That could have occurred.
You know what I'm saying? Like it could be like, for example, in Alahan, todo dra in Alahan gilon monogi, gagi maiti, gagi i pekka, gagi i salamelago, gagi hulu bilen, gagi gini papa I there's so many lo gagi gimagard giza in Alahan. Gagi gi municipality in Alahan, zagwano siya na distit antes na yan naman gagi Espanyol tatungo mano na manos masago antes ti maluk sinanya gagi didigi o gagi giza Agatna Spring o gagi giza there's so many places. So before I come to a conclusion that this is not necessarily totally erroneous at this point in time, I would like to also see if Kopinala told the whole area, and then in that different section, it's still in alahan. At na giza in alani po mapupona mas kaduko na lugar po mapega ilan fio gisagan hanum giza lejon. Gaya talo giza gizinalan dandan. Gaya gige papa tinaga. Gaya gi yotsubanda bulan na naan lo gilugar na i municipality nila. So ang para pataolog na sen magay tigwidas ti pusen magay mantiman potsugi na. In order to be able to pass that legislation that says Kwatali, and everybody commonly sees this as that, then maybe we may want to ask Mr. Chairman to bring out the committee reports that would reflect the public hearing and the presentation on the officials at that point in time as to why they said that it's unrecommended. They're professional recommendations because notwithstanding anything else, I have confidence that my colleagues, my past colleagues, they base themselves on what is presented to pass. Pues guanabra na zimolo gi wisdom itsamoro anu dadagyo sama dadagyo. So we presented something that, but I'm not sure. I know some of the players then, and I remember they were pretty professional in terms of the process that went through, and that's why 2395 basically gave that common, was that name place? But it really is the name place. It's but the municipality is not Natanhanum. Natantano, yeah. Atantano, or to say that this is incorrect, because I don't think that that's how we do our zoning maps. We do it in terms of the the lot numbers, the municipality, and all of that stuff. And that's why I'm saying, it might be good also to look at 2095. Are they just making that as historical reference that is better known as, ne? See, David L.G. Simmons is better known as Familiang Zomuk or Familiang Katsa. But the real part in a legal sense is the surname, the municipal name. So before I go off and say that, yeah, this may not be correct, it would be prudent on our part to be able to say, well, just how far north, or is it within this area? So, sigas di mapatintiyo. The federal commission, mala no napati, manai. Mala ji otru I Chamorro Land Trust, mala tapati. Aji tali otru. Traces ti napati, right? I Chamorro Land Trust, I Federal, ni Matsuli, or Dosa. Dosa, no? Partial A and B. Pues, mauling na ta suguro sa ang paratausa I name place, no, versus the real municipality. Tita Jojon or Tita Tsotsugi I survey map na giza didigi ng municipality sinanya tilig niya na malolo giza dandan o ledzon dahil fantalo na tanlatsin isti maulog paragato ledzon division ledzon yeah ledzon amigwa Rata magay na ledzon paragado no zaman na honulo simpitahan naman lalo taw-taw gilo. Pero and I say that with all sincerity sa lob nagabi sa nganyo wahados na mighty giniulo dan mighty inalan kakuntungo right across the church, St. Joseph Church, mighty. Sa sige na sumaga Yasagwao, mighty, right across. Pues malaza tabatgay na the municipality I lot number sa sinya empeño ta soda the committee report, Mr. Chairman, and consigi Vice I archives so malak na si committee report y 2395. Sa itige nagagi sempre todo i presentación ginin i Public Works, ginin i EPA, e qua ko manholom i land management law, there was a task force that comprised, and I remember they gave about 11 sites, and out of that sites they keep narrowing it down, if I remember correctly, down to 4. Then out of the 4 that was brought into the public hearing, and then they narrowed it down to, of the 4, which is the most suitable site for this. And my understanding then was as a result of the integrated solid waste management program, and that had to deal with recycling, composting, waste to energy, incineration, and a landfill. Those were 5 different components that they said that would take care of, and it's probably still true today, and that the best site was down in that area because it's already a disturbed area. Todi Besino man M2, which is the highest, I think, no? You just told me that this morning. M2 is the highest level of industrialization. Gaya gipapa todi gorko an tahasu an matu pangsangwa za pakpak todo dozo. Nasu za mantaza gasi za juru kumimason. Todo dosta ju esta virgin pristine land. Esta ju majulang todo do para istina klasin of a programa. Sige na kalan wana ba na palalaksi. No, they cited that area as the most, because it's already one. Let's say the recycling can be done, the composting is going to be done, the waste to energy. It's gina mauligi papa sa hihut PT power plant. Tichagugo pa ma an masongge zo mono na gatugi PT power plant man mamatina si talo nebo na source of power. Pes ijem ipo matsuli todo do di metallic waste and todo po stores hihuta tali commercial port. Ang pomachogo na programa gihulo giza inalahan gina lugar na maalok lejon pus distidzo chago na extension court todo do papa papiti parla po machogo di waste to energy. An idzo na po mapega todo do i ocho na components kalan chago pus idzigi na masangonyo dispensal. Na ito na lugar na mapropone gitoro do i-professionals gina tempo. Ti Senator Dota gimalok og jaw gi papa. Sa todo doon po ma-recycle, pat po ma na hano todo do di abandoned vehicle, tons and tons. He who the commercial port, matulagi, ma-states, ma-break it down, manasua todo ilanya, manasua todo freon, manasua todo do i-tires ni sina, pes matulang za mabel, mano na gato gibat ko hihut tagwala ju falalago todo do cross island road ni todo do ji abandoned vehicle sa poma hahala to papa didn't make sense pos itzige ma representa pos itzige le kuna ma bensi ma convince i muna what was it? Oh, that's the public law. A committee report in cinema spipia makumbensi i 23 na losta na i 22 esta mafatitina si foundation after election. They were already setting the foundation to be carried forward into the 23rd. That was the best site. And even an iti waste to energy tatunga papa gi GPA gina tempo ka koopera man mamaisin GPA waiver ni po fan masonggi ilanya. So sinab i-exhaust fume manulo mas pus kung todo dyan ay malulufan mahano i-asu or the smokestacks are going out rather than if it was gaigi ledjo mahano na todo do papa some people I love you got to all the way down to Santa Rita itzuhulo talo tatungwa na size na sagan hanum ang para i-sanitary landfill, sempion dia ju talo izota surface water. Tanisita surface water para ta dam, dyan sa kaso ta jama ki izota aquifer. Sa tatunga hafa mas dumadsama ki aquifer ki sa papa itu maalok non-porn pollution. Kumikilinga si non-porn pollution nangga juli mas megina kereta po fanalum man manhalum tali militar. Pus todo ji lanya gua nulia na muzungo ki zomu garat sunata na todo istilanya. Istilanya na te ava parade gui hulo muna na papa. Jadi diti ambil na lanya ja pumpola lum gi hanum na system unsina un distrosa. Sa sti ilana ti an hanum ti sina integrate. Water and oil do not ever mix together. So all of that information, Mr. Chairman, was brought forth. Now we're looking at, well, where was the site? Now we're making reference to the word Guatali versus the word, and as a professional, you're saying, well, you know, you can call it a new name. And you know, we have a lot of new names. Guahaji Liguan, no? Lohagasa Liguan Nanyazo. Right? The guy gives a municipal. Right? Lo Guahaji Hulu gets a Parisville. Nebuzo na nambi sa subdivision ano natin is guy gives Sapun Point. Right? Sapun Point, guy gives gita muning Oka, guy gives making a different name place lo Guaha loki nebuna na ansiata na guana nebuna na ni tutungo pumunun siya sa 8 na klasin subdivision mahatsa. Pus name place talo no na. Sa history provides for that. Lo ang motogi para official na dokumenta mo no na matsotsugi i lot number i municipality todo no pus nisita na ita atan tati ko juma alok better known as ne like unoy example i familia inanno la motogi kotiti malok si katsa no Inga si David Simezo, no? Sige, posiste na pago, tisina pago na patapuno asti sa matausa better known as versus what is really the real thing. But we do have to be able to go back and find that out. So you're right. I don't see. Now the next question I'm going to ask, okay, having laid all that foundation, is this: that area next to track 2411, lot R14. That is zoned already?
Yes, Senator. That was part of basic lot 439-1, which is the better known as now, track 2411.
So, dinga ha na isti, right? Istina nebo is track 2411. Stop at the original 439.
That's correct.
Pes matulaikan na niya eh. That nebo na lagat manayin, a nebo na designation, but it really is still that part of the same family of Trakov. So it's not, in your professional opinion, it's because, you know, since I've been here 2 years, I see a lot of requests for rezoning. The people want to come to their elected leaders and say, look, for whatever their reasons are, we would like to rezone this. So this, if indeed when you go back and check all of those better known as and so forth, if indeed this is still A, notwithstanding the fact that, you know, the notes are wrong, you know, is this compatible, this partial partial A, no?
Partial B.
Partial B? Is it compatible with for this legislature to rezone it without fear of any other? I mean, is it compatible with its twin brother that left the coop? Parewa na nahaga. Because the legislature have done rezoning with even less supporting. It came from the same body of land one Gorko came in and carved out his share and made it at the highest level, M2. Now, was that done by the legislature by chance?
No,
Or
sir.
was it done by TLUC?
It was done back then, the Territorial Planning Commission, which we now know as the Guam Land Use Commission.
Right. And it made it
M2.
M2.
Right.
At that time, who owned these properties that they
I,
were able to carve it out?
I don't recall the owner, the original owner at that time. I don't have that information with me.
The original owner would have been for the whole area, right?
It had the basic lot 439.
Right, the basic lot. Can you find out who owned that? Because now I know that the federal government now owns partials of that. And then the other partial, is this whole area, was it a tract of property that were federalized? Or was it an original owner? You know, in fact, I'm curious as to how all of a sudden the federal came and had the property in there. You know, we had private property people came in and bought this land. Who did they buy it from? So how is it that now the federal government can say, you know, that's always been federal, let me carve out my share, and then the rest will return back to the Chamorro Land Trust? Everything that was returned back was under the idea that, oh, this is ours and we'll give that back to you, but we're going to keep our... It was what? Okay, so then that answers that. Thank you, Senator Pengene. So that's a land exchange. We exchanged that property for one of their other properties. And then the rest, the Chamorro Land Trust. I mean, that was never a private owner. I mean, and again, who were the original owners in that area? Because, Mr. Chairman, I'm learning a lot now that this was a basic lot, 439, and a large chunk of it, as a result of being purchased, was being under the territorial TLUC. I remember that. Carl, that was TLUC, no?
Planning Commission, Territorial Planning
Yeah,
Commission.
Territorial Planning Commission,
At that
TPC, yeah, at that time. And was able to zone this M1. I don't know who owned it at that time, but it appears that this vicinity map, not to scale, the notes are wrong, according to land management, that select lots are zone M1, heavy industrial, blah, blah, blah. You know, I can't hardly read who was the surveyor, but he's putting his professional signature on a note. Those notes are part of this document, absolutely part of this document. And was it filed with land management?
Yes, Senator. This map is on file with the department.
Yeah, and at that time, back in 2001, was there any review by land management to say then, as you are saying now, that's incorrect? Who would have reviewed this? You would have to go back and see who reviewed this, because that was brought in, and everything becomes part of the legend. Everything comes part of, yeah. It even says legend there, yeah. And then you have notes, and then you have references. That helps the government understand the greater presentation of the survey map. So, but does this survey map now become unregistered as a result of that note?
No, no. What we do have is that this map is already recorded. It's on file.
And what is it recorded under?
It's recorded under document number 641990.
Is that document number on this same thing here?
That's only part of the map that I have here. But,
Yeah, okay. Can we have a copy of that? Because I don't think we have that copy, because it's just this portions here. But this is probably the same
Yes.
as that. So then if that's already registered in there, and there's no what's the word, redacting of that number 4, that's saying it's subject lots are M1. See, in fact, it says subject lots, not just one lot. I think S means plural. Subject lots are zone M1, heavy industrial, residential, as of approval of this map. So if this map has been approved by the government at that time, 2001, then that note, there must be some corresponding, I don't know what it's, any other documents that will support this note, that subject lots are zone M1, heavy industrial, as of approval of this map. And I'm wondering, is there any other supporting documents? Because you said this is just a survey map.
That is correct.
Yeah, and then you need a zoning map, right?
That is correct. If you want to verify the validity of that note number 4, you would come to the planning division, and because we maintain the official files for zoning designation, and we would verify that that is incorrect.
So will you have a copy of that document? Could it be, in the world of possibilities, conceivable that that part is not updated?
The zoning map? Or
This is survey,
right.
and then when you go in, I mean, is it conceivable that it's not up to date? You know, that we have not caught up with that portion. Because this is a reference
Right,
document
right.
to say, can that person come in and say, look, here's the, because, and the reason why I ask that is because when I see documents that are requested for rezoning, you know, I just see, you know, the lot number, this, who's the owners and all of that, then boom, it exists under law. Then you would have to take it to your zoning. Is it computerized or is it just the tickler file?
The most current zoning map that we have is a scan image, but you won't find the updates on that. What we would do is that we maintain all the changes in another file, in an amendment file, zoning map and amendment files, that we would go and go back and verify that particular zoning. And for an example, the copy that was made that I have here is one of those that have yet to be shown on the zoning map to begin with.
So it's conceivable
Senator
that
Shim,
cause,
before you do,
yes, sir.
I know that you said you wanted a copy of this map. This map is actually, this map is half of what this is.
Yeah, that's what I made
Just go
reference
ahead and
earlier.
photocopy the other half of this
Yeah,
map.
not
so
just, yeah, that'll be fine because I just wanted to make sure that we're talking on the same page when he raised up that portion, and now, thank you very much. So one thing that I do know that even in past, even as far back as that, you guys really have been short-staffed to update. I remember Carl Uggan, the director, you know, just pounding away that we have so much that we need to bring up to speed because these are very, very important things. Lands can be lost or whatever. Surveys can be turned in and taking government lands and bringing and so forth. We need to automate ourselves. Brings us up, you know. I mean, it's a real hard job, and that's why I'm asking that question in the worlds of possibilities. That this is a surveyor that puts his professional signature on it and made those legends and made those notes, and we can go back to our files and look and say, oh, it does not exist. Is it possible that it has not yet made it into that as a result of the circumstances that and that there are others that has not gone into that. There are others. I'm just trying to look and that I don't just say right now, you know, I'm trying to think in terms of some sort of logic for me, my own personal, if this, then that, you know, if and only if that, what are the, so I'm trying to eliminate, so there is real strong possibilities that indeed it is zone M1 and may not have made possibility exists because there are others that has not yet made it to that file. It has not been updated.
Let me answer that in two ways. The possibility exists that the amendments to a zoning change, you may not see that in a current zoning map. Okay. In reference to the partial that we're discussing now, you can be assured that that's not a M designation zoning partial. It's an agriculturally zoned partial.
That's what's showing on your record right now.
Yes.
Now, what would it have taken the surveyor? What would have been the next step for him was just to get it into that, right?
To
The rezoning map.
okay.
There would have to be. This is a survey map. He
That is
surveyed the
correct.
area,
Right.
chung, 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 chung.
Right.
And then the other one, when what's his name, the TPC, had the variance map. So there's two maps we're talking about.
Yes, there's a zoning map, and the one in particular for the property is a survey property plat.
Okay, what's the difference between a survey map and a zoning map? Wouldn't it be just the same because you're showing all the boundaries of those property that you just surveyed, and now you say, I want this to be commercial, I want this to, and I'm requesting the TPC or the TLUC. The map will not necessarily be different. And then on top of that, if there are some conditions to the variance, then you can have what they call conditional land use or something like that.
Conditional
Or
use.
conditional use, right?
Conditional use.
And they have to abide for that. Like, for example, they need to
That
get
is correct.
a road in, they need to have access, egress, they need to do this, and they need to do all of that stuff, you know. So this surveyor he was just commissioned to do a survey,
That is correct.
and he overstepped this by putting a note that shouldn't have been there. That's what you're saying.
He
And land management should have seen that at the time the survey was in and says, you know what, we're not going to approve this because what you're saying on 4 subject lots are zone M1. At that time, the government should have said, no, this survey map is not does not meet the threshold of it being approved as a survey map until you eliminate. That's at that point when the person is coming in, until you eliminated that number 4. But it was not. And the government accepted it and recorded it. So that becomes a legal document, right? And then if indeed lot number 4 here, I'll just go note number 4 comes in, they can still come in and say, here's my what's that variance map? Is that what you call it?
zoning map.
Here's my zoning map. Thank you. And it's zoned.
Like, you could come in, but we would verify that to.
That's what I'm
verify
saying.
the,
Yeah, so that's all it would have taken.
Yeah.
It was for him now to just say, here's the zoning map.
Oh, a property map is one of those where you would not bank on zoning. You would verify that in terms of the validity of that particular note. If you remember, it's just a note on a map.
Yeah, but then when you look at it, I mean, a huge tract of the original was part of the original is zone M2.
M2,
So
yes.
they would not be a major opposition on the part of land management because it's compatible with the neighbor, the original land
Okay.
where Gorko's at.
Right, right.
Did you
Yes.
have a point of inquiry, Senator Cruz?
Just a series of follow-up questions, but
Okay.
I'll wait until he's done, I guess.
Okay, yes, of course. But I can yield to you and let you speak if you want.
Okay, thanks.
Okay.
I'll jump in then. Carl, you mentioned that the reference to Guatali in 2395 is not this area here. Is that correct?
My understanding, Senator, my understanding is that the Guatali is north of the project of the partial basic lot 439
North of the parcel 439, if you look at the vicinity map, is U.S. government reservation. Is that what you show on your map?
On the vicinity map, yes.
You mean to tell me that John Tenorio, Department of Land Management, provided information to the Guam Legislature in the 23rd Guam Legislature to have them set aside military property that didn't belong to the government of Guam to put the landfill?
That, Senator, I can't ask because I wasn't part of the that part when it was still being discussed as a bill. I wasn't part of I guess the committee that looked at it. I only came across it in terms of when I was looking at the maps here, that the partial B was actually in the Tantano site. And then therefore, if partial B is the one that the proposed landfill is going to be situated, then well, indications are that it should be at the Tantano site and cited correctly.
But but 2395 never mentioned Atentano, did it?
I don't recall the specifics of the law itself. It may have
No, do you have
specified Guatali?
2395? The primary site for the landfill shall be the area of central Guam known as Guatali, located near the old Gorkos oil site. The government of Guam and its agencies shall immediately commence the planning development of this new landfill site so that it can begin to be utilized at the earliest possible date. In the legislative history, I mean, in the Act itself, Section 2, it says known as Guatali, located near the old Gorko site. And now you're saying Guatali is in the federal reservation at Tantano, north of the 439 site.
Yes, if you don't have the opportunity to look at this map here, but on this map here, if you look at the map and cutting across the northeastern side of partial A, which is the north side of the lot, you would note that it's Guatali River. So Guatali, as I had mentioned earlier, is, my understanding, north.
I understand.
Yes, right.
That may be your understanding now, but at the time that the legislature was working on the legislation 2395, they were told Guatali near the Gorko site as the area that they had been setting aside. And 15 years later, you're saying, I don't care what they said in the 23rd Guam Legislature, what information they were given. To me, Guatali is someplace else, so I'm not going to address this as Guatali.
No, Senator, I'm not saying that. I was asked the question, where is Guatali? And I referred that my understanding was north of the subject property, which is 439-R1. And I was only stating for the record what I do know, what's on partial B, from my research and coming across in the maps, that was at Tantano. Certainly, I'm not going against the law. If the law calls for Guatali, then fine. All I was doing was clarifying where these are at.
Lot B that's in this parceling map, that went to Chamorro Land Trust. Is that correct?
That is my understanding, yes.
And that same lot that went to the Chamorro Land Trust leased to GRRP for the purpose of a landfill.
That is my understanding.
And so, even if you think or you believe the name Guatali belongs someplace else above Atentano, all the legislative history and intent in stating it's near Gorko, and this surrounds Gorko, the area that was given to Chamorro Land Trust, which it subsequently released for a landfill, was all in fulfillment of law that thought that this was Guatali until you decided that they were wrong and it was someplace else? Or are you determined that it was wrong?
No, I am just stating the facts that what I see is on maps is Atentano, which is on the south, and that's all I was trying to state. by no means am I trying to go against the law.
But if the court's going to try to make sense of this and trying to fulfill the intent of the law, where would the landfill go?
Well, if it says Guatali, then it's got to be in the Guatali site.
If it says it's Guatali, they described as Guatali, but it's near the Gorco site, and very specifically states, you're going to say that it's going to be north in the military reservation?
All I'm going to say is that it's in the Guatali site. Now, whether that Guatali site is in the military reservation or off of it, if you look at the maps, and if you refer to near Gorco, it's not really specific. Near Gorco could be south, could be north, could be east of that partial. So which near Gorco do you mean?
You weren't part of the 1994 group.
No.
Have you bothered to go back and look to see what they had studied and the areas that the meets and bounds of the area that they were talking about? Because initially when we were talking about the landfill in Inarajan, we all referred to it as Dundon for over a year. In fact, I'm almost sure that the solid waste plan that came before the legislature refers to it as Dundon. It wasn't until recently that we started to refer to it as Luzon. These name places are inconsequential in what needs to be done when the legislature says in 2395 we want a landfill built near the Gorco site in an area that they think is called Guatali. They may have been wrong then, or maybe you're wrong now, we don't know. But the thing is that they've determined that that's where it was going to be. The government got land that went to the Chamorro Land Trust, and the land that they've leased from the Chamorro Land Trust is this parcel B, whether it's Guatali, Atentano, or whatever, but it's the lot that has been leased for the last 8 years for the purpose of a landfill. But you're going to, at land management, say that you won't allow a zoning of this area as for landfill purposes because it's not Guatali as you recognize it, regardless of what 2395 says.
No, if you want to come and rezone, or if the action is to rezone lot 439-R1, then that is fine with us. If lot 439-R1 is to be rezoned, and only a portion of that is to be rezoned for the private landfill, then that's also fine. Again, what I was trying to say was that at the southern side, what I saw on maps was Antantano, and what I understood to be Guatali is north. But does that negate the zoning or the rezoning for basic lot 439-R1 or a portion thereof? And the answer is no.
No, I'm not talking about the zoning of the main part of 439. I'm just saying today, as documents come through your office for clearance of a landfill on a piece of property, 439B, that the Chamorro Land Trust leased for the specific purpose of a landfill in fulfillment of what it believed was the intent of 2395. Is it my understanding that you're going to deny the zoning or the approval of a landfill on Lot B because it's Atentano and not Guatali?
No, we won't. What we would have a problem with is that if there's no law that authorizes the use, for example, if the current zoning is still agriculture, but in that legislation, the legislatures at the time when they enacted the public law authorize the use for the landfill, then we wouldn't not have a problem. So there's two ways to authorize a landfill.
Which public law? Does it have to be done by the 29th Guam Legislature, or can the Department of Land Management, recognizing that 2395 and subsequent acts on the solid waste has not been repealed, and that the intent of the legislature was to put a solid waste facility adjacent to or near the Gorco site, is that sufficient for land management at this point to approve an EPA request for a landfill on parcel B, or will we need to have a specific zone change from this legislature, or would we just need to have a reaffirmation of 2395 that area there by Gorco was supposed to be for a landfill? You're saying we don't need to have an M1 or M2 zoning from here, but if we say it's supposed to be for a landfill, you guys will accept it. Which one is it?
We will not have any problems clearing off on the permit if the language in the law was specifically states that the landfill is to be an allowable land use on that subject property. Otherwise, if there's no language there that allows for that, then certainly that property has to be rezoned into heavy industrial.
2395, you mean?
Yes, I'm referring to the 2395.
95.
Right.
If you, because of the fact that it says Watali located near the old Gorco oil site, that's going to be a little too, that's difficult for you because you're insistent it's at Tantano. I'm just trying to figure out, what do we need to do now to make it so that the Department of Land Management will approve the permit for the landfill on Lot B, which was leased by the Chamorro Land Trust for the specific purpose of a landfill, for the specific purpose of fulfilling 2395. You're the only department that doesn't seem to understand that. Your other branch, the Chamorro Land Trust, recognized it and leased it for the landfill. But your branch of your division of Department of Land Management does not.
Well, for one thing, since we're mandated to uphold the zoning law, we want to ensure that the use is an allowable use versus one that would just lease out a property for commercial lease, for an example. So there's two different mandates that we have. But from a zoning perspective, what we would want to be ensured is that the use is allowable. One way to do that is to so state in the public law. Another way is to have the zoning be rezoned to the proper zoning, which is heavy industrial. So if either one of those two is not very, very clear, then we would have a hard time trying to approve a permit.
Would it be sufficient for this legislature to amend 2395 to strike Watali and put 439 -R1 Lot B?
We don't have a problem with place names. What we have is, if you want to be very specific.
That's what I'm saying.
Right,
so
yeah.
I'm saying the place name of Watali is confusing to you because you determine it to be someplace northeast of this site. But the legislature at the time was of the opinion it was someplace else. And they thought that they were in the legislative hall and that's what they were talking about. And so I'm just saying, what would be better? We have two different, I proposed an amendment reaffirming. Would this whole amendment be necessary, or would an amendment to 2395 taking out Watali and putting in 439-R1 Lot B.
That would be my recommendation, is to cite the actual lot number, which is lot 439-R1, and then qualify that with the portion known as, or shown as partial B on the map, which is this current map that we're looking at.
So my amendment, where I say Legislature and Guahan hereby reaffirms its prior authorization and permitted use of Lot B of Lot 439R1 Santa Rita, containing an area of 352,872.12 plus or minus square meters, is shown in the map recorded at the Department of Land Management on August 8, 2001 as a sanitary landfill. That would be sufficient for you?
That would be sufficient, but I wouldn't call it lot B. I would qualify it by saying.
No, it's
partial B.
parcel B
That-
of Lot
439.
439-R1.
That would be correct. That would be correct, Senator.
Thank you.
Okay, can I just continue on? I just yield to him. Basically, I had spoken to Mr. Antalan. It really is what we can do here is just exactly what BJ was saying, was that Senator Cruz was saying, was basically to make it abundantly clear, you know, that it will be the policy of this legislature, as, you know, mentioned in 20. That's what I'm saying about the 2395. I gave you a copy of it, you know, when he made all of those name places and so forth. Those are very better known as, but they're not very precise as to what we're talking about. So the idea here is to make it clear that, and it has been done by this legislature, that that specific area of the partial 439, whatever, Part B. And, you know, you can also put, you know, some additional parameters that, you know, bordered on a lot to the north, R14 track 2411, you know, which is zone M2. So we just rezone it because it's really one of the same property but was just subdivided. So now the Chamorro Land Trust should be able to have its, through the policies of this legislature, that lease which they had intended it to be for this purpose, you know, and that will make it clear the intent and make the intent precise, so that you will be able to say, I'm following the law. The law that was passed in 2395 was kind of nebulous, a little bit, you know, not clear enough for you to have a comfort zone to be able to do that. But given this amendment and can we take a 1 minute recess to be able to do that amendment in writing?
It is in writing. So I assume that it is?
No.
It's already there. It's already there.
No, I had that, but I don't think that
That's exactly what he had, Senator.
My recommendation.
Part is the history, Part B is the reaffirmation.
Yeah, but when I spoke on your part of your amendment is the B, that's the enactment. What we do is that it says we reaffirm its prior authorization and permitted use of Part B to lot 439-R1 Santa Rita, containing the area, square meters as shown on the map that's recorded at the office of. The map that he's recording is a survey map of the Department of Land Management on August 2001 under instrument as a sanitary landfill. Now, I'm not sure this language says we're rezoning it from A to M2. Yeah, Mr. Antalan, do you have a copy of that amendment on B?
Yes, I do.
Yeah, it seems that my understanding is that we need to rezone it from A to M2. That's basically what you're saying. This language is not suffice.
No, that's the opposite.
What I was.
He said he's okay with this amendment. We don't
No, I'm asking him now on that part because he mentioned earlier what he, Mr. Antalan.
What I was trying to say earlier, there's a couple of ways that the body here, the legislatures, can authorize a landfill, so to speak. And one of them is through a rezoning, and the other one is to allow the use to exist within that.
Which is
particular
stronger? I mean, that's like a conditional use by legislation. It will still be agricultural, but
Right,
we allow
that's
the
right.
use of that.
Right.
I mean, has that been done where you get the, this by law, something is agricultural, but you can use it for M1 or M2, or you just say you're going to have a sanitary landfill, and that's the proper zoning is
Two.
what? M2.
Right.
So
My recommendation would be to rezone it to M2.
okay, so then what we can do here, if you look at the language, Mr. Antalan, instrument number as a sanitary landfill, and further that the same area be zoned as M2. I mean, you can have both, but that really zones it M2. This one doesn't zone it M2. It only says agricultural.
Which allow, yeah, what this amendment, I believe, would allow the use rather than a rezoning.
Right. It's only allowing the use, but is that strong enough that somebody can come later on and litigate this? That wait a minute, it's an agricultural. How can you allow M2 activity to occur in an agricultural?
Well, the body can do that, Senator.
See, like but the body can do this, and you will accept this,
Yes.
and then you will go ahead and clear the way for whatever they want to do in terms of their permitting.
That would be correct.
That's a matter of record right now,
Yes.
and they don't need to zone it M2.
No.
And can you tell me other precedents that this has happened?
Not in terms of a heavy industrial zone, but a classic one is the soccer field down at the Agate, where the towers are at, KWTG or something. One was also, the other one was up at in the north, the Deditu soccer field. That is still in its current zone, but the use has been allowed, currently A zone. And then the other one that was done the same, but for the southern soccer field is down in Agate. So the use has been allowed, but the zoning still remained the same.
So nobody yet has ever challenged
No,
it in that
no.
area. But is it challengeable? Is it challengeable?
No, because you authorize the use to
Okay.
exist.
Okay. Well, thank you. Thank you very much.
Thank you, Senator Shimizu. Senator Respicio.
Thank you very much, Mr. Chairman. We spent a couple hours on this amendment, and I think it's been somewhat productive, but for me the issue is very simple. You had the Public Law 2395, a previous legislature that in Section 2 of this public law said that the primary site for the new landfill shall be that area in central Guam known as Guatali. Then you have in this public law a description of what that area is. And over the years, if you take a look at that lot 439-R1, this law came before it was parceled out, right? It came before that lot number was reverted back to the National Park Service.
That was probably correct because, let me backtrack a little bit here. The current map that we're looking at is just a retracement. It did not separate. The severance occurred previous to the map that we're looking at. Yeah. I just don't have the map that severed out the two partials, but what I can say is that the current one is just a retracement, so it was not a severance map at all. So whether the law came before the map that we're looking at, I don't know. I think it may have, but I can't be sure on it.
And so then, you know, and I don't want to rehash what's been hashed out before, but this amendment that's being offered by Senator Cruz and others, my name is here as a co-sponsor, You said that it would be sufficient to have land management authorize a permit for a municipal solid waste landfill.
That would be correct. Obviously, what's going to happen if it passes into law, we would have to comply with the law itself. And so that would, that would allow us to give clearance to permits. The other alternative is also if you did an amendment to the law and actually rezone it, that would also, obviously, it's going to go to public, through law itself, and then we would comply with the rezoning as well.
Yeah, and hasn't that always been your agency's position with respect to this issue? Didn't you make a request to the Attorney General regarding this matter, whether or not those two public laws are to be considered valid and followed?
We did, and the guidance that we have received back was that the two public laws were, so to speak, null and void. And I don't know in terms of, we're not legal.
Just to qualify, the Attorney General has taken this position for as long as we've been involved in this consent decree, that the government of Guam shall not recognize any other option other than the option that was identified through the consent decree process, correct? So didn't she respond, didn't her office respond and say that your question as to the validity of these two laws which identified this area for a private sector landfill is moot because the government of Guam is currently in a consent decree process?
I believe that's pretty much correct.
Yeah, so, the issue for me, Mr. Chairman, is very simple. I was not part of the 23rd Guam Legislature, and it was the 23rd Guam Legislature that, based on all the scientific analysis and presentations that were made at the time, voted to set aside the area near the old Gorko oil site to be a new sanitary landfill. And over the years, through this reason or that reason, and all the stumbling blocks and artificial barriers that were placed on this private sector company, it's just been very, very difficult for the government of Guam and for the community to realize the true closure of Ordot Dump and the opening up of a new landfill. It's very appropriate and timely that we move this amendment into this bill. Because you have two options right now to comply with the consent decree. One is a government suggested option that's now under receiver, and the option that you've always had was a private sector option that would cost 1/5, possibly the cost it would take if we were to have this landfill in Dundun. This amendment is absolutely germane to the bill. No one's arguing germaneness, and I'm happy about that. But all this time spent on if the 2001 map was correct or was it in error or this or that, we have to recognize the current statute, and that's what land management said. Public Law 2395 designated an area near Gorko to be the new landfill site. And the hiccup is that area is not Guatali. They're saying it's Atantano. But the description is the exact same description that area was assessed for a landfill. Would you say that's correct?
That's pretty correct.
Yeah, so, let's not participate in the furtherance of this artificial barriers, and let's please move to put this section into this bill, so that way land management can do their job. They tried to get this thing clarified through the Attorney General, but the Attorney General does not want to recognize this because we're under consent decree and the issue is moot. Now that's an artificial barrier. That impeded him to be able to sign off on the zoning requirements so they can move forward with the permitting requirement. I hope we don't have short-term memories and we never ever forget that the EPA spent the last 6 weeks through an administrative hearing where it was determined that administrator set up artificial barriers to this process. And so this amendment will just remove those artificial barriers, let this company go through the normal course of requesting for permitting applications, the normal course of applying for these kinds of uses for this property. When they're not asking for anything more than what should be for any other company that wants to get a license to this kind of operation. And so, you know, we don't need to reference the map anymore. If you recognize and believe that 2395 set aside the area near the old Gorko site to be the next sanitary landfill, and if you recognize that that law is still on the books, then this amendment, it dovetails with that that spirit of that law. Now, if we no longer believe that Guatali is a site for the landfill, in the last 6 years that I've been here, I've never seen a bill from any senator ever introduced to repeal that particular statute that said Guatali shall be the site for the landfill. The problem is the governor of Guam entered the government of Guam and the people of Guam in a consent decree process which the legislature was never a party to. I've argued the legality of that consent decree process and how the sites were selected and how Guatali was automatically excluded because they said at the very basis we need 100 acres. Why? Because Guatali is 80 acres. You know, and that's for a separate argument I recognize, but I'm asking my colleagues, Mr. Chairman, to recognize what this government has done over the years to set up a very different standard from what that standard ought to be applied equally and across the board. And so with this amendment, I just want to make an amendment to the amendment in the last sentence. And it doesn't do anything drastic. It just simply changes the word sanitary and added in municipal solid waste. So it'll read as a municipal solid waste landfill.
Okay. On the amendment, striking out the word sanitary and putting in municipal solid waste. Any objections? No objections?
Mr. Chairman, I'm again pleading to my colleagues to recognize what we're trying to do here to be consistent with an action that was done by previous legislature, and I'm hoping that we can support this amendment. Thank you. And can I just, Speaker Wampat, maybe Carl can help us on the section under double I. On the on the fourth sentence, so it would be the last sentence of that subsection, double I, where it says document number 90143 and this document number 115867.
It says you're corrected, 5867. That's
Oh, on the top rather. On the first sentence of double I, this 115667. Should that be 115867 instead of 115667?
No, Senator, I'm not too familiar with that document number.
It's right here on the map. It's
Okay, which map are you referring to?
this lot number 439-R1 on partial A.
It reads here, Senator Spishu, 115867
On the map, right?
on the map.
Okay, because on the amendment it reads 115667.
That's correct. The one shown on the amendment should read 115867.
Okay, can I then just offer that as an amendment?
Okay.
'Cause it's beyond a technical amendment. If
Yeah.
it's a mistake, it's a mistake.
On the amendment, no objections?
Okay,
So
thank you.
ordered.
Thank you again, Mr. Chairman. And I thank my colleagues for listening.
Okay. On the Cruz amendment as amended, Senator Pangilinan?
Thank you very much, Mr. Chair. Mr. Chair, I listen very intently and trying to also follow what has transpired. And while it is true that the law 23-95 has never been repealed, there had also been subsequent legislation passed by this body, which one has argued and has been argued as giving tacit repeal of that law, or at least a reevaluation of the designation of the Guatali site. There was additional laws that were passed which allowed the U.S. EPA to go through a process of the scientific evaluation or the engineering and environmental evaluation of any new sites for the designation of the new landfill. So while we said at the time 2395 was passed, that came upon the recommendation of the EPA as well as DPW at that time. And then subsequent legislation, when there was no movement on that, and we went through the process of the consent decree, basically, that said, you guys got to find a new site, that there was then additional legislation passed that required then the search committee and the selection committee for a new site based upon environmental evaluation. And while we argue whether or not that process is fair, whether it was biased, or any other argument, that's a different argument to be made than the fact that the legislature said Guatali is the site and is a suitable site. Now, through the different environmental evaluation process of the participation of the U.S. EPA as well as the Guam EPA as well as DPW has re-examined that, then and selected another site, then I think that to go back and now just rezone Guatali is not something that I'm willing to do. So while, again, and the debate on whether or not Guatali was unfairly excluded, unfairly evaluated, et cetera, et cetera, et cetera, is a question that can be challenged and is being challenged, I think, and I'll lead that challenge to continue on. But just like Let's On, if that's the site, they still have to go through the rezoning process. And if Guatali is a suitable site, then let it go through the rezoning process. This would bypass the rezoning process. And I have I will leave the rezoning process in this case to, the zoning board and have the parties apply to that. I think what they want to do is is bypass that process. And I can understand why, because of the designation that that's a suitable site. The other thing I wanted to just bring light to is that the site that was identified at Guatali at that time was part of a larger unsurveyed government land and property, an undivided property. And the recommendation came over based upon, at that time, as everybody understands, a environmental assessment of the suitability of that site through an engineering firm, Wantanori and Associates. Now, if I recall correctly, and I may be wrong, and anybody can of course, find the facts that would bear otherwise, but if I recall that the engineering assessment site, the site that was subject to this environmental impact assessment is not parcel B. That it was, in fact, it may have been part of 439-121 or that 439R1, the entire site of the undivided government land or unparceled government land, but it was not parcel B. And if I remember correctly in some of the testimony that I thought I heard, is that the environmental assessment was over 200 feet away. The property that was assessed as the Guatali site is over 200 feet away from parcel B. So to say that and rezone parcel B now, I think is something that I'm not willing to support at this time, given all of these questions that I have in my mind. But I'm fairly confident, and again, I will, defer otherwise on that. So absent those questions, then I'm not prepared to rezone parcel B for this purpose. Thank you.
Thank you, Senator Pangilinan. Senator Shimizu.
Thank you, Mr. Chairman. I support this amendment. I mentioned things earlier as to why, as it relates to the scientific aspects of it. Where do we locate an integrated solid waste management program? And like I said earlier, that was what the expert convinced me on the 22nd, and of course on the 23rd. And I left the legislature for about 13 years. And one day, people came up to me and said, Dave, they're going to build the landfill over here at Lejon in Inalahan. I said, no, they can't. There's a public law that, if I remember correctly, there's a public law. And they go, no, it's a done deal. This is months before they went on the professional public hearings. I said, well, no, it cannot happen because that has been decided already as a result of the task force that was in place. I had confidence in them. I have no personal interest where this will go, only if I hear. My only interest is in the best interest of the people of Guam. We live on an island that's only 25 square miles, 30 miles long. So anywhere you put it is going to be in everybody's backyard. Let's just make sure that we put it in like we do when we build homes. We put our restrooms over here. We put our dining rooms over here. We put our bedroom in here. We don't take our toilets and put it in the bedroom. In some cases you do, but you partition it off. But just generally speaking, I don't bring it and put it right there on my dining table either. So the experts on home design says, no, this is the way we got to do. We got to do all this stuff. And then there are experts that we have to go to for building permit to look at your electrical and so forth. So I said, no, that's an impossibility that could happen. He said, yes, no, it's a done deal. I said, how do you guys know about it? I said, well, we heard it through the grapevine. Isn't it one of the most powerful things that we have here in Guam that exceeds all the telecommunication here? It's called telephone na lahay. Lana na sinadig man, pew! Tunisita, laser. So that came to me. I'm sharing this with you. And at that time, I was very happy in what I'm doing and so forth. And I said, no, it cannot happen. So I says, yeah, well, you watch. So months later came down. Lo and behold, there were schedules of public hearing going around the island, and it went to Inalahan, and I was there. And I went there as not as a somebody, former senator, not as a nobody, but just as a body citizen to go there and find out what is going on. Well, the response to me was like, I felt like I was just hit right in the stomach. Yeah, man, you're no more. You're not sitting center. Forget it. You're asking all these kind of questions. I even hear from the professors, all them senators, they know nothing down there. Man, tay tiningo no siya papa. So I just went up to the person and said, "Afo may kilang man tay tiningo. Ano atin siya bula man may duka. Bula man gugod papit masya mo no. No na alok no na. In fact, kwanto papit mo para pong kumpara pag waki papit to." So in other words, when I see that kind of attitudinal statements and comments, then it does confirm to me that yes, indeed, they're going through this process because they're required to, not because they want to, because they've already made their decision. It's been, and the word is, it's a done deal. Estama casa ni hafa. And I always still believe that the people rule supreme over our government, and that we want to make those public hearings meaningful. One of the comments that came back from me, from the quote unquote the smart ones, was that, oh, no. We need a huge landfill. That place is too small. I'm going to tell you, we don't need a huge landfill. We have very strong recycling. We have a very strong waste to energy, composting, reduce our waste streams and reuse those that we cannot reduce completely. And that's why in the hierarchy of the integrated system, landfills It's not the first choice. It's going through those process, and whatever you can't get rid of human in a smaller amount, it goes into that sanitary landfill. But no, we're going to go and build it in a huge tract of land. And you know what? That's what made me decide to run and get elected. Did everything that I could. Now we are not only dealing with our own level of government, we're dealing with the federal supremacy. That even our own laws are saying, I'm supreme. No. But that's the way it works, the supremacy of the federal district court. That's even tougher, even at the expense of being told that we might be held in contempt. I got elected here to represent you, the people of Guam that are watching and all those that are not even watching. So that concerned me. So I said, I'll see what I can do. What can I do to come back as a body to this body? Because I chaired the Committee on Ecology then for the 2 terms. It don't make sense to me. We have 2 sources of water that comes from God. The aquifer, which is way down, they call it the lens. You damage that unless you have God powers to go under Guam to repair it. Once we really damage that with increase of populations and non-point pollution, we definitely have to have something like Hoover Dam. We dam the surface waters. The watershed. The south has the watershed because it has clayish material. That's the geology is in clay. And you know, just see water. Water runs on clay, it doesn't go down. But up in the north, it is all limestone. Limestone is like cheese, Swiss cheese, got holes. When God gives us rain, it goes down. And it also takes the non-point pollution that goes with it. So if we destroy that, 30 miles long, we need to be able to go to one of our natural resources, and that's the watershed. Start damming it. However, man is not perfect to build a perfect sanitary landfill. This whole island, in and of itself, is volcanic, built on a lot of faults all over the place in the hospital. Right now, I went up there with some of my colleagues and some of the citizens that know that area, grew up in that area. I grew up in Tamuning and married a lovely woman from Inalahan, and I fell in love with the people. And I fell in love with the island in that part of Guam. Now, what God has created, we, because of policies or whatever reason, is going to go over there, and we are going to regret this. And this is the time that I would try to continue, and you probably continue to hear me even after January 4th when I'm no longer in this body. But let me tell you, we need to be able to start damming the Ugam River. I worked very closely with Governor Ada and Lieutenant Governor Blas. In fact, he was one of the authors of that integrated in the early days. So he was a man of vision that had that. To get Ugam River, to dam it, is the sweetest water that we have today. We saw the ads from the CCU. Drink from the tap. Well, Ugam is sweet water. There are 6 water tributaries that run through, goes all the way down and gets deposited at Fena. Lestane pagu Fena, Zuni Militar, sama Fitma Gatu. So we better start looking at that. If we destroy whatever of the lenses that we have up there, because I'm going to tell you, pollutions travel down in the caverns and the caves, underwater, goes all over the place, man. We get one well that destroys it, it travels. It's going to take almost so much for us to try to mitigate that problem. But we have so much potential down. In fact, I'll never forget one of the senior senators at that time came up to me and said, Dave, when it rains here in Guam, the whole place is wetland. In around where the church is at, they all called, that's why they moved a lot of the people from the church, because they said that's wetland and it's a flood zone. But the pura flood zone with all these developments that are occurring. What I'm trying to emphasize here, that it was a done deal way before. And I agree with my good colleague that that's another issue that somebody can bring up, and I choose to do that. To be able, again, to look at our moral compass. Look at our moral compass. On the economic side, I have no vested interest in any private companies. I have none at all. Left all of that. So I can serve the people of Guam without having to worry about saying, oh man, you're in somebody's pocket. Well, you go to my pocket, there's a big hole there, my friend. So I won't allow it. But it's done deal. On the economic side, we are here today as a result of a receivership, as a result of a court order saying that we must come up with a financial plan to be able to take care of the opening of Legion. $20 million. And we must get the approval of any financial scheme, not necessarily from the district court. We have to get the approval. This legislative elected body must get an approval, because it's ordered by the courts, on a receiver that comes from, I don't even know where they come from, but that's really, it's a private enterprise that this elected body has to go to. I still live in America, and I have my right to speak without fear of intimidation. That court case has a chilling effect on me, thinking about it. So you talk about the economics. You talk about the economics. Private enterprise wants to go and build it. Chamorro Land Trust is leasing their property. They're getting income. We're not having the problem to try to go find a $20 million. That's taking away $20 million, as far as I'm personally concerned, from some of our aging retirees who are dying, and have not been able to get access to their court-ordered COLA. This is one court order. Economics, private enterprise. What happened to this? You know, when we first got in, we believe in private-public partnership. Well, here is a perfect example of that philosophy, and it's being hampered. Dahil po mahatsezu, taza ni 20 centimos patagasta. I have no interest in that group. My interest is trying to protect the natural resources that we have. It does not make sense. It does not take a rocket scientist to know that we don't build your basula gihilo hanum. On the last visit that we went there, 2 feet down, we hit water. The footprint of this landfill is going to be like hopscotch all over the different places so that they can build it. In less than 2 years that we do put the first cell, maybe 5 years, we're already looking at it to be 5 stories high. We're in the typhoon belt. That typhoon belt, it always comes from the south, from the Philippine Seas coming in. All of that 5-story that we built, because we can't go on a landfill. It's not a landfill down, it's a land up. What are we going to do? Typhoon comes, shoots that all over the place. We don't know what is going in there. Does not make sense. Economically, it does not make sense. And I say this because otherwise, the people were actually right when they said to me through the telephone, Alaihay, esta munadzan man mabendihit lala la. And guess what? And guess what? They went through, and months later, ladies and gentlemen, we surely like to announce that after a scientific thing, that we've done all our other stuff, it's going to be in Inalahan. Oh, be damned with all the waters sheds that are up there. That saved a lot of people during World War II. The different concentration, all the way up on Muffet area, Buragi Sagan Hanum, Sagan Shrimps, Sagan Asuli. Sige mo naalala, itatotano. Hanum masipuntanti. So I stand in support of this, and I hope that when this goes through, a lot of the bureaucratic process that has hampered anybody who wants to come in and build a landfill, as a municipal solid waste landfill, and sanitary at that, at their expense, I welcome them. I welcome them versus that of the government of Guam going and saying, we're going to put, you know what? They talked about rezoning. Well, why didn't they go and, number one, condemn the property first, then rezone it, and then spend $11.5 million, and then also spend another $4.5 million that was taken out of the schools. That 11.5, if memory corrects me, was they took from all the different agencies, even your agencies. They took about $11 million. Niti jottay tano. Hano zon sagi zon fangasta $11 million zon hano gatigi gima. Saling half a day no mangastos lapi gigitano niti jotta. So that's another example of a done deal. Taja fanan ne mati ora ni pumapoli itsalan yala matsokin pakyao. Mati itsan tour erosion. Di man manano gati man mangago sitano di permit no pamfanhat sa tsalan. Sumago gi papa zo lili bulan truck manahalom malatan at sadidik. For manhatsa dito nanulo pago kumata fundraiser ta nanulo at check izu $11 million washed down. Kalan mon man matsutsudayit sulapi. Idzo na pisaportistina. Because one, it's logically and economically correct. Two, it's morally correct. It's morally correct to do that. Malazata na kerere dos. Paraguay imena. Thank you very much, Mr. Speaker. I stand in full support and my name to be on that amendment. Thank you.
Thank you, Senator Shimizu. Okay.
Call the question, please.
Okay, on the amendment as amended, there's already a call for the question. Okay. Is there any objection to the amendment? Okay, there is an objection. Okay, to the amendment as amended. So all those in favor of the amendment to the amendment, can you please indicate by raising, there is an objection, please indicate by raising your right hand, your hand. 1, 2. Okay, there are 8, amendment carries. All right, guys, we've been through some contentious things, and let us take a break. Okay, for first off, before we go take, are we done with these gentlemen, please? Okay, and I want to thank you, gentlemen, okay, for this, and with that,
just one thing. Can we still get the better known as?
Okay.
That would be good. And
all right.
I want to thank you, Carl, very much. You've really educated us on that, and you've paved the way so that we can indeed start looking in terms of some alternatives. Thank you.
Okay, so the committee of the whole will go on recess until and be back at 2 p.m. Thank you. Everybody were there. I had to recuse myself, so I can't vote. Even if they forced me, I would have voted no.
interest derived from the financial agreement shall be exempt from taxation of the government of Guam. Again, of course, C, approval by Guam Economic Development Authority. No loan authorized by this section shall be entered into the Board of Directors of GIDA has approved by the loan of the resolution. And D, approval of voter is not required. E, approval of loan is returned Guam pursuant to 50103K, Title 12, Guam Code Annotated, hereby approves a borrowing of by the government of Guam for the purposes and in the principal amount authorized by this section, provided that the loan is entered into subject to the terms and conditions mandated in this section. Then this particular amendment was drafted by my office in coordination with Stan Dirks, financial advisors, bond counsel, advising on the options that could be utilized, especially in regards to these deadlines that have been imposed, and ensuring that we have a vehicle for again the loaning out or the receiving of about $20 million. So I'm looking towards members of my body for the approval of this amendment. Thank you.
Okay. On the Howell amendment, any discussion? Senator Pangilinan.
Thank you very much, Mr. Chair. Mr. Chair, I rise in opposition to this amendment, of course. And it goes back to the same opposition I had with regards to the way that we're structuring the ability to get to this money while cutting the ability of us to pay the income tax refunds and the COLA. We are now, the income tax and the COLA in the hospital bond issue is a general obligation bond. And every time we go in and we allow a pledge of general fund revenues, we are giving up, basically, or hindering the ability of the government to move forward on the COLA, the income tax refunds and the COLA bond. And that's why, and I'm not just objecting because I'm objecting and providing alternatives. And I did that yesterday with regards to providing that alternative. Unfortunately, my alternative provided a way to float the bond and allow income tax refund recipients and COLA recipients to also get some payment when the governor gets his money. And so that was an alternative that I proposed. And unfortunately, the body decided that they wanted to move forward with an alternative that allows the governor to move forward and not pay using the authority for the borrowing of the COLA and the income tax refunds and not making any payments at all to those obligations and those priorities. And I see the same footprint here. And that's why I'm opposed to it. But I do want, and again, it just saddens me that every solution that this body wants to move forward is a solution that will make income tax recipients and COLA recipients wait longer while we do something else. That's the only reason why I had supported the borrowing to pay the COLA and the income tax refunds, because we have gone on with this government and continued to jet off to China and Korea and transfer money here and there without paying the refunds. We're just kind of like putting them off to the side and prioritizing our expenditures for all these other things instead of that. I had hoped and I had struggled in this body not to borrow that money because I don't like to borrow money. And I struggled and passed legislation that would force this government to put aside the money we owe to the people first in income tax refunds. That's why you have seen me move forward in creating this income tax efficiency payment trust account that requires that we set up that we set aside the cash every month. Actually, we set it up every 2 weeks. It's supposed to be when people pay their withholding tax. These are people that are giving us the money to the government because they have an obligation to pay tax. And they're trusting us. They're saying, this is what we owe because these are the employees we have. We don't know what we're going to be like at the end of the year, whether our employees are going to owe taxes or have refunds, but this is our best estimate. And so take this money. If we overpay you, when we got into the end of the year and my employees file their refunds and their income tax return, if we overpay you, make sure you have the money to pay them back right away, because we didn't have you wait. Government of Guam, we're giving you the money so you can run the government, but run the government well. And I have done it so that whatever this body decides as the proper formula, based upon a 3-year history of how much of that withholding tax we take and we put away in cash, so that when people file their tax returns, we will have the cash to pay them back. I have worked hard on that bill. It is as close as we can get to ensuring that the money is deposited without being a governor. You know? It takes the governor to do that, to follow that law. But we haven't done it. And finally, when just of total and sheer frustration and seeing this government continue with all the extravagances and the travel, $50,000 a month in travel, while people that need chemotherapy treatment for breast cancer. These are the kind of calls I'm getting. People that have somebody that they sent to the Philippines because they had enough money for surgery on their back, because they had a broken back on their vertebrae, that they send them over there because they thought they had enough money, send them over there, and then they find out they're short. But you know what? They're short by $800, but they have a $2,000 tax return, coming back to them, and they can't get it out. So now they're stuck there, and they're scrimping. People have given up. People don't even come to ask us for donations anymore. People are out there holding medical fundraisers. How many do you attend, Mr. Chairman? I see you there. I know you feel for these people. And we do it, and the people have no longer are they just asking for donation. They are out there struggling hard while the government holds back on to their money. And when we finally said enough is enough, let's borrow the money, because we can't pay them. Let's borrow the money and give the people back their money and implement that law to make sure we don't fall behind. And the reason why we fall behind is because we're so far behind. So we take this year's money and pay 2004 taxes. But if we go with that bond and move forward on that, we can pay all that off, and we'll have enough money to put it aside to pay for 2007-8 taxes next year. But this bill takes that further away again, because it now takes the authority of a general obligation bond, transfers it to this, and once we do this, the likelihood of doing the other one just slips further away, and that poor lady waiting for her refund to continue chemotherapy is just not there. Hope is slipping away. And that's why I'm saying, let's preserve this general fund. Let's go with other options on this thing. Or if they do it, then let's have some for them. I'm not saying all of it, but I'm saying whatever we take to give to the governor, let's take some for them too. But no, that was rejected yesterday. And now we're back to the same thing, And that's really my concern here. And like I said, I have an amendment that says that allows another bill that allows the governor not to intrude upon the general fund, but to take the compact impact fund and reprioritize what he wants to do there. If this is so important, then reprioritize that so that he can get his $20 million without impacting the general fund and our ability to be able to move once the market's done. Because we do this and the market rebounds, believe me, it's going to take still longer, because now we've got a $20 million pledge on the general fund. We haven't even approved, we're going to pay it back with revenue bonds. We don't even have a revenue bond. We were criticized because he said when we added this $100 million to do the income tax refunds, I was criticized very, very heavily in this body, and our whole side that it was going to lead to a tax increase. That doing that was going to, it's all going to be a tax increase because we can't support it. Well, I tell you what, you know, the revenue bond that we're talking about to repay this, you're going to need to triple or quadruple the tipping fee to support it. So is that what we're saying now? That the only way that we're going to be able to put this money back to pay these income tax recipients is to quadruple the tipping fee? Because that's what it's going to take to support a borrowing to pay it back? It's the same. If that was a fair criticism, that borrowing the money would increase taxes, well then borrowing this to depend on a revenue bond to pay it back is also fair to say that you're going to quadruple the tipping fee. And do you want to do that? Do you want to go from $8 a month to $32 for residential? Maybe some people say that's fine. Yes, you can afford it. You're not waiting for your income tax refund for chemotherapy. Or how about the businesses? They're going to go now from what, $60 a ton, $32 a ton to $250 a ton? Some people are going to get their businesses are going to see their tipping fee increase from $2,000 a month to $25,000 a month. Or $8,000 a month, 4 times. We've seen the increases. That's what this is when you're saying you're going to rely on a revenue bond to support the tipping fee, to support the revenues, to do the bond so that you can repay this. And that's why, again, you know, it's like I was trying to find some kind of middle ground here where we will move forward on providing some partial relief here, maybe full relief here, and so forth. And if we do this, then we bring other people with us. We bring those people waiting for their income tax refunds for chemotherapy. We bring them with us. We make a special payment to those guys, you know. That's really the only thing I'm really arguing for, you know, is how can we not impact, or if we do it, and we may not be able to go with the entire 200 million or 246 million right away. But the way that we had written it up was that the governor can go for 20 and nothing else. And I'm saying that, you know, let's give him an incentive to go for more so that he can take some of it to satisfy this and have some so that we can make, you know, more than 1 or 2 or 3 or 4 special payments even. It may not be that we're just going to pay the back. It may be that it's all for special payment of income tax refunds for those who have to bury their loved ones or don't want to bury their loved ones and send them off to medical care. You know? Why can't we do that? Why can't we see a solution to doing that? You know? Yet we're prioritizing this and this alone. I don't mind prioritizing this. I prioritize this in the proposal that I put in yesterday. I prioritize that of the first month amount that we float on that general obligation bond, $7 million goes to the governor to satisfy this. Then maybe we could have done the line of credit for 6. We're up to 13. You know, 7 more and we're done. You know? Or we take and then we put in the issue for the compact impact. All of a sudden we're up to 20 and we still have the ability of not encumbering the general fund so much that we're not able to do more. And we have that option of going out for more. And that's I'm not pleading for myself here. I'm pleading for the people out there, the retirees. I mean, you know, somebody was joking, well, the governor's going to go to jail. Well, some of these guys, thankfully, because they've lived a good life, will be going to heaven, I'm sure. But they're never coming back. You know? And so that's what I see here. And if I could make one plea is just to delete maybe section 2 and 3. You know? Let's figure out a way to collateralize this so that it doesn't impact the general fund, because we're not going to take it out of the authority there and not use the Section 30, because that is part of the general fund. And if we figure out a way of finding a revenue source like the compact impact that I have proposed, or like just securing it from just the revenue bond itself, if we decide to do that, even, and figure out a way to do it, then we can move forward, and we haven't jeopardized the ability of the general fund to move forward on that general obligation bond that we've authorized before. That's what I'm asking for. So I would like to make that amendment, would be to delete number 2 and number 3 under subsection B of the amendment.
Okay. There is an amendment on,
You've objected to the amendment already, right?
I think that his objection was on,
Oh,
based
just
on a,
To the amendment as a whole. But we,
so that he can unobject.
okay. Hold
He's
on.
looking at basically, under terms and conditions B, to delete number 2, shall be a general obligation of the government of Guam, and 3, may also be secured by a pledge of Section 30 revenues. Point of information,
And 2 anywhere
No.
here.
if you go to B, terms and conditions.
Is this the one?
If you go to B, terms and conditions, numbers 2,
So you're going on B
yeah.
and the subsection.
No, it
2.
says 1, 2, 3, 4, 5. You see
Yeah, I
that?
saw, yeah.
Yeah, so what they
So then
is-
it's not section, it's a
No.
paragraph
right.
or sentence.
It's,
So sentence 2,
it's,
paragraph 2 is to be deleted.
it's delete for where it says in parentheses 2 shall be a general obligation of the government of Guam, comma, and in parentheses 3 may also be secured by a pledge of Section 30 revenues.
So that's the motion, and
Now,
then,
the motion is to
then
delete.
4 will
To
become
delete 2 and 3.
Right.
Yeah, 2 and 3.
In the spirit of comite and harmony within the body, I have no objection.
Okay. On the Pangilinan amendment to the Cabo amendment, Senator Shimizu, your point of information.
No, it's already taken care of,
Okay.
and I have no objection. to
All
it.
right. So on the You know what, you guys? Why don't we do this? Can we take a 30-second recess? So in the spirit
actually-
of Comitea,
Yeah.
in the spirit of Comitea, let's take a 30-second recess. So the author and of the amendment and the pleader of the.
I like it.
Oh, you
It's
like
good.
it?
He changed it.
Okay, so you want to put.
It's
on-
easy.
Keep then 2 and 3, but then it says it shall read now. It shall say shall not be a general obligation of the government of Guam. And number 3.
Take out may also and shall,
And just
be
put.
shall not be secured.
Clerk, you got that? Okay. Okay. Do we understand the amendment to the amendment? Okay.
No objection.
So the amendment, if there's no objection to the amendment to the amendment, so ordered. Now, on the main amendment, as amended, on the main amendment, okay, if there are no objections to the amendment,
Can I speak on it?
sure, Ms.
You know, I echo the same sentiments. I've always echoed the same sentiments. In fact, I was the first one out of the discussion when we had the Gita guests here in terms of the $20 million. And I did ask them, you know, given the conditions of the market as rapidly changing as a result of many different things that are occurring, they want to go and get just $20 million. And I asked them, under the same terms and conditions for $20 million, how much more can we get, you know, given their expertise? And I do remember, and I'll stand to be corrected, that they mentioned, well, maybe we might go up to as much as $100 million, you know. And my concerns is, yes, we need to address the $20 million. We got to come up with a financial scheme to deal with the landfill in Lejon. But by the same token, you know, we also have a court decree, a judgment on the COLA class of, and we have at a number of, I think third time we've put in appropriations or authorizations to borrow the money up to $92 million plus the hospital plus the tax refund and so forth. So if logic prevails that they can push the authorization up to $100 million, you know, I'm of the same position as Senator Pangilinan for the COLA. So I have problems if we're only going to ask for the 20 million and we could get 100 million. And the 80 million that's left over there, that can be prorated out to the different obligations that we have. This doesn't. This just gives us, again, the $20 million. So what I can do here, let me just go jump the gun right here. On the Calvo amendment, it says on the authorizations to borrow, on subsection A, the Governor of Guam is authorized to borrow on behalf of the Government of Guam as provided in this section from one or more banks or other financial institution an amount not to exceed the amount necessary to provide $100 million for purposes of financing the cost of a landfill, the COLA, the tax refunds, and it will be prorated out, the balance that they can get. So we're authorizing them to be able to go and see if they can get the loan up to $100 million. And if they come back and say, well, we only got 60 million, well, 20 million can go to the landfill, and the other 40 million can be divided out to the other court obligations we have in terms of the COLA. So that will be my amendment, to authorize them to go as high as 100 million, and if they are not able to get that, then they can. It's an authorization. This is an authorization to borrow. We authorize the governor, they go to market and try to get.
I think it's necessary. Why don't we just take a 1 minute recess so that we can. Okay, let's take a 1 minute recess.
Well, you know, I mean, that's what I'm pushing for. You know.
Okay, committee of the whole back in order. Senator Shimizu?
Thank you, Mr. Chairman, and thank you for giving us the opportunity to be able to build a consensus as to what we're trying to do. What Senator Pangilinan and I have always been trying to do in this particular issue is that we take care of the need for the governor to get the $20 million in the short term.
Saying all of us too that are.
Yeah, and eventually
Thank
I will. And then I'm laying the foundation, so allow me that opportunity. So once we. Please do not interfere,
Senator,
Madam Speaker.
Thank you, Senator Shimizu. You still have the floor, sir.
And I do. Thank you. And I'm saying this so that the viewing public will see that. And through your chairmanship there, we got together and we did a hybrid that was able to bring together among all of us here, Senator Calvo, Senator Speaker Wampat, and the whole gallery of chairs here, but so that the people of Guam will understand what we've done here. Really, politics is really trying to get two or more people to come to a consensus. And in this case, we were able to do that. And our concerns here, at least my concern, and I'm sure you all share it, is just the way to get it done was that we don't only address the funding need for just the trust, but we also take care of whatever we can get, especially in this season of Thanksgiving and the festivities, that we may be able to come up with a cut and paste and go back to earlier amendments, which I will turn over to Senator Pangilinan, so that we not only get the $20 million, but we get a piece of the pie that will take care of the long-awaited, maybe not all. Just like the earlier COLA was at $14 million, so now we can at least get some for the COLA, some for the refund. And I think, and in the other authorization, as we mentioned earlier, that says the priority was for the hospital that we all supported. So with that, Mr. Chairman, I'll withdraw that increase of the $40 million and then turn it over to crafting the merger of the different proposals that were given earlier. Thank you, Mr. Chairman.
Okay, thank you, Senator Shimizu. So Senator Shimizu's withdrawing his. All right. Okay, so we're going to go back to the amendment as amended, the Calvo amendment as amended. Are there no objections? Okay.
I just want to thank the author of the amendment for working with us on this. I think that it's allowed us to move forward, and I think we're going to accomplish the options that we want to in order to ensure that we resolve the problem of the landfill, as well as ensuring that we don't leave people behind on this.
Okay,
I want to thank the author.
Okay. So on the Calvo amendment as amended, no objections? So ordered. Senator Pangilinan.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to then go back and present an amendment that was considered by this body. The amendment, because the ban is basically the same, pretty much been taken care of. That option is being folded into the amendment that just passed from Senator Calvo. The ban would not be necessary anymore as a separate authorization. And now I'd like to go back and present another option that the governor will have, where he can use, remember, he can use a combination of these options. He doesn't have to use 100% of one. So the authorities that he has allows him to draw from different wells, you might want to speak, to achieve getting $20 million. And this would allow him to do that. And if he does it in this manner, then the other parties also get some, which is really what everybody's objective has been through this whole process and the dilemma that everybody's faced. So I'd like to present the amendment that's being passed out. It has, I don't even think it has my initials.
Yes, it does.
Oh, yes, it does. And I'd like to add Senator Shimizu as the second co-sponsor on the amendment. That would be to replace the last paragraph of subsection I with the following: upon the issuance of the bond, so forth, etc. And it's before you. And then it ends with the words, the amounts reprogram. And underneath that, it has the delete references to the bans and the notes out of 383.
Okay.
And delete
So
the new sections. Oh, I'm sorry. Yeah, since we're deleting the bans and the notes, it'd be to add this to the last paragraph of subsection I. Yeah.
Okay, so this is to add to the last paragraph.
Yes, of subsection I.
Okay.
And then we delete the references to the bans and the notes and the authorizations pursuant to those.
So that we're all understand this amendment is to add to the last paragraph of subsection I, and also to delete all references to the ban. Senator Calvo.
In the interest of harmony and comote with the incoming Ways Means Chairman of the 30th Guam Legislature, I have no problem with this amendment.
All right. Thank you, Senator Calvo. Okay, on the Pangolin amendment as approved by the Pangolin and Shimizu amendment, okay, as is no objections from Senator Calvo, no objections, so ordered.
Thank
Senator
you.
Pangolin.
Thank you. Mr. Chair, I wanted to add another amendment to the bill, and this is in reference to the last amendment that was just, not this one, but the one previous to this, in reference to the affirmation, I guess, or the change with the lot number and replacing the word Gotali with the lot number and so forth. I went back, and just for the record, I went back and I reviewed the environmental impact assessment study, and I was correct. When the legislature was presented with the option of where that landfill was going to be, when it identified the site as Guatali in 2395, it's very clear from the environmental impact assessment that was done by the engineering firm at that time that it was not Parcel B, that the engineering assessment had actually assessed Parcel A as the footprint site of where the Gotali was going to be located. And the reason why it identified that at that time was it was government property. It had not been exchanged with the National Park Service from some property that came back to the Port Authority of Guam. The federal government gave some property back to the Port Authority of Guam, and in exchange for that, they received a portion of the of lot number 439-R1, and that it happened to be Parcel A, which is where the assessment said the landfill would be sited. And so when the legislature made its decision to say Guatali, we were looking at a map that reflected Parcel A and not Parcel B. So now this legislative body, by the adoption of that amendment, has basically said, when you build the landfill in what was originally presented to this and authorized by this body in 2395, don't do it on Parcel A, because we don't even know that's where the environmental impact assessment was. It's not there. We don't own that lot anymore. Let's go to Parcel B, which was not evaluated, or definitely not evaluated as extensively as Parcel B. And that's all being borne out by documents that have been filed in court proceedings because of the move to try and get Parcel B licensed and so forth. And that's why land management has said, we can't affirm that this is the site of where the landfill was pursuant to 2395, because it just wasn't there. The problem I have in doing that now is if we do that, now we're going to bypass any kind of, in my opinion, public input, or at least not guaranteed. And if you take a look at Parcel B and the entrance to Parcel B, if you think that Lechon is in your backyard, the people that live next to Parcel B, the landfill won't be in their backyard, it'd be in their bedroom, because people are living right next to this lot. I mean, you're talking about houses bordering this lot that are adjacent to the lot. Not neighbors, but next door neighbors. And so by that action, I'm not sure what the effect is going to have on public input on that. So I'm presenting an amendment that says, notwithstanding any other requirements, that the provision of that section that says now a landfill is permitted on Lot B or Parcel B, even though the environmental impact assessment said Parcel A. And by the way, there is current rules and regulations on the siting of a landfill. Never mind all the engineering stuff, just where does it go? And I believe the rules and regs says that you don't want a landfill where there are residential houses within a quarter mile of the place. And is that an artificial thing? Yes. What is it trying to do? We don't want to recreate ORDOT. No matter how strict you are with your environmental compliance, there is a certain smell that's going to occur, no matter what. And so that's why for the siting of a land, just general, I don't care where it goes, the general rule is, pursuant to EPA and DPW and so forth, you don't put it where there's within a quarter mile of residences. Well, absolutely, with this, you're going to violate that, or at least you've got people right there right now, and so forth. So I think that these people deserve to be heard, or at least deserve to have what their concerns are going to be, will be, are. And we received some kind of assurances from whoever's applying for this license now. Well, we all know who it is. It's GRRP. That their application now, that they got to hear what these people are going to say. Because if you heard it, I mean, I heard it when we had the public hearing in Santa Rita, or it wasn't a public hearing, it's a public community meeting, because I don't think it was a legislative proceeding, but the community meeting on that issue. And you heard the people there that just to clear the road, people are driving within 10 feet of their front yard. That's what so how do we mitigate all that? If by what we did, we may not have an opportunity to do that, or at least the general public that's going to live next door to this. We had a pastor that had said they're within 100 feet downwind of this site. They just built a brand new church. So we want those people to put their whenever there's any kind of application put into this, I want those people to have the opportunity to put their concerns on the record and have GRP, who's saying it, put on the line how they're going to resolve that issue, how they're going to deal with that issue, and if we have to put it as part of the conditions in the contract or the license and so forth, that it be put there, and if they don't comply, then they get shut down, or whatever the regulations that can be put in place to guarantee these people, that we're not going to end up like ORDOT. Even though ORDOT is, a non-Subtitle D compliant landfill, we want that even with a Subtitle D compliant landfill, there's going to be issues, and that these issues must be addressed, and that the departments and agencies that are going to be granting approvals to this must know what those issues are from the horse's mouth, and so forth, and have them deal with it prior to signing off on anything. And this is the same thing that should happen in Ledzon if it goes there. If it doesn't go there, then we don't want to replicate ORDOT with residences right next door from the start. It's not even going to take us 20 years or 30 years now, because the problem at ORDOT is that it's continued to grow and people have moved in there. With Parcel B is people are there already, and we're saying go there now. That's exactly what I think happened with that amendment, is we're telling GRRP, go there now. And I want the people that are there now to be heard, to have a say in this whole process, and so forth. And I think that without this, then there's no guarantee of that. With this, there's a guarantee. So I'm sorry I may not have had it covered, but it would be to add the following section to the bill added by the most recent amendment by B.J. Cruz, which would be, notwithstanding any other provision of this section, a public hearing shall be held prior to the issuance of any permit or other government or autonomous agency approval of an application relative to the landfill on Parcel B.
Okay. Do you have that? So, okay, let's go ahead and take a 30-second recess so that we can get that thing passed. Okay, the committee of the whole is back in order. Senator Guthertz on the Pangilinan amendment. Ma'am, you can sit down.
Thank you. Thank you, Mr. Chairman
I know
and
you're-
Speaker. After consultation,
Madam Speaker. No, go ahead.
Mr. Speaker,
Thank
after
you.
consultation with our colleagues, I would like to make this amendment to Senator Pangalinan's amendment. And it reads, notwithstanding any other provision of the section, a public hearing consistent with the Guam Solid Waste Management Rules and Regulations shall be conducted for any proposed landfill on Guam. And by the way, the Guam Solid Waste Management Rules and Regulations provide for the timelines for a hearing. It's within their rules already. What? For any proposed municipal solid waste landfill? For any proposed municipal solid waste landfill. Okay. Solid waste. All right.
So, ma'am, you're correcting your own
Yes, I'm
amendment?
correcting my amendment to say, shall be conducted for any proposed municipal solid waste landfill on Guam. So we insert the words municipal solid waste after proposed and before landfill. Municipal solid waste landfill on Guam.
Okay, so we're, just to understand this, Senator Guthertz, you are basically rewording the Pangilinan amendment. So you're striking out all the Pangilinan amendment and basically saying rewording and replacing it with this. Senator Pangilinan.
Thank you very much. The reason why I put in my amendment is that my concern was that because the legislature in its action had now said that the landfill shall be located in lot or parcel B and that it is permitted use there, I thought in my review of the applicable regulations as well as statutes that when you construct something in a permitted use area, that as long as it's permitted use, then no public hearing is required. So by the fact that the legislature, in changing the original intent of 2395 and the site, I'm convinced that it's changing the site from what was recommended in 23, and I want this to be very, very clear for me on the record, that the presentation that was made to the legislature in terms of determining Guatali as a suitable site was based on an EIS study that identified the landfill to be on parcel A. Now this legislature is basically saying, we don't care about that. So there's even, I think, conflict in that we're reaffirming our action. If you were reaffirming our action, the action of the legislature was pursuant to the recommendations made by the EIS study, which determined that the site of the landfill was in Guatali, parcel A. At that time, an undivided lot that belonged to the government of Guam. Parcel A is no longer in control of the government of Guam, and the remaining lot that is in control of the government of Guam from lot 439-R1 is parcel B. So now we've changed the location of the landfill from parcel A to parcel B, and it's now we're saying it's permitted use. And that to me is where the ambiguity may occur later on down the line. And I may be completely wrong on this, but I just look at it in this manner. If I have an R1 lot and I want to build a single house, a single family dwelling, because it is a permitted use in that lot, I don't need any kind of public hearing at all. I can go get my permit, they issue me my permit, and off I go. If I want to build a fourplex, it is not a permitted use, it'll be a conditional use, or I need to go and rezone the property. So I have a choice. I can go into a conditional use or go into a rezoning. If I go to the conditional use, I need to have a public hearing, where I didn't need one for a single family dwelling. I'm concerned that because we've now said that the landfill, which was originally authorized in parcel A, pursuant to the recommendation made by this body in the AEIS study, is now being changed and is being said that the permitted use of parcel B, which was not part of the original assessment, for the siting itself, it was environmentally assessed as it relates to the entire lot. But after doing all that, they said, put it over here on this corner. Parcel B is down here in this corner. Now we're saying take that, which we evaluated and said that's where the landfill will be built, and saying build it down here. And because we've said you can build it down here, it's a permitted use, that it may now come in conflict, and you may now make the assessment or assertion. Now the owners of parcel B may say, give me my permit and I don't need to go to a public hearing because the legislature said I can build a landfill in parcel B because that's where it's supposed to be pursuant to the actions of the body in this bill. And so I'm concerned about that even if you have the rules and regs that say you got to do this, because of the legislature affirming that that's a permitted use, and again, they may be completely different. And I'm saying, so what I'm saying is, and I've also had some discussion with EPA staff on this idea of the requirement of a public hearing, and the initial assessment was they're just not sure. They're not sure if they are required to have a public hearing on the permit itself. You know, they may be, and so I'm concerned about that. And if it does, then you know, we're good. But if it doesn't, then the people around parcel B will now have no say at all whatsoever. And so that's why, even if it's on top of an existing one, I'd still like to put it in there as my original intent, because at least I know for sure that a public hearing will occur. And I just think that they deserve to be heard because they were there first and these guys are moving in now. The people who have been living there right next to parcel B, adjacent to parcel B, and now we're going to say, you guys, GRRP, can go in and put your landfill right next to these people. And it may or may not require a public hearing. And I'm saying, well, I don't want to take that chance. Even if it's redundant, at least, you know, and I don't want to say that, and I'm certainly sensitive at least to the proponents of this that want to put that landfill right there, you know, where people are living right now, right next door, that want to put it there.
Point of information, I did not vote for Public Law 2395, Mr. Chairman. If you want to go down that road, we will. Because
that's right, I did. But I voted to put it up there. Not where this body just voted, where the retiring senator just voted to put it on Lot B. That's the difference. I'm saying, that's right, 2395 identified it as Guatali, but it's up in parcel A. The bill, the amendment that just passed, which the good senator just voted on, was to take it and move it from parcel A and put it down here in parcel B where people are living like next door. So he's correct. He did not vote for 2395. But he certainly voted to take it up there away from where there were nobody, where there's nobody living in parcel A because it's so far in, to put it to parcel B where people are right next door. And I'm saying, because those people are there first, we got to hear them out. Even if we have to hear them twice. And if we don't, I am sensitive to the fight here and not to delay it, let's hold it within 15 days. And if it's 2 hearings, let's hold it within 15 days and let's do a permit hearing anyway. You know, that's my original intention. I just wanted to be absolutely sure, because I'm not absolutely sure about the requirement for a public hearing based upon allowing and permitting a landfill to be built on parcel B. So I object to this amendment because I think it goes away from what I've intended in terms of providing additional security that the people will be heard. That's all.
Senator Respicio, on the Guther's amendment to the Pangilinan
Thank you very
amendment.
much, Mr. Chairman. Mr. Chairman, I want to rise in support of the Senator Guther's amendment, which we think builds upon what the previous speaker wants to do. I'm not opposed to what the previous speaker, retiring speaker, wants to do, because certainly we have to have a public hearing whenever permits of this kind of magnitude are issued, and that requirement is already there pursuant to the Guam Solid Waste Management Rules and Regulations. What we just did earlier by passing the amendment that reaffirms that area as a municipal sanitary landfill, and you heard the Director of Land Management said it himself. When I asked him, pursuant to Public Law 2395, is this area we're talking about the same area as described in Section 2 of 2395? It says located near the old Gorko oil site. He said yes. He said yes. He said yes, and I said he tried to resolve this with the Attorney General, and her office came back and said that they didn't want to address this issue. It's moot because of the consent decree process.
Point of information. He said yes because the property next to Gorko is Parcel A. Parcel B is not next to Gorko.
But the description that I described, and I said if this description is covered under that lot number 439-R1, are they one and the same? He said yes. But because he couldn't move forward and sign off on the permitting process, everything was just at a standstill. So, I don't oppose the requirement of a public hearing because that's what's already required. I would not oppose this amendment, which replaces the previous amendment, but I would caution the body that if we were to adopt what the true intent of the good senator from Barrigada would be, where it says, or other government or autonomous agency approval, Mr. Chairman, why are we setting a higher standard again and placing an artificial barrier on this very, I admit, very controversial, very contentious issue? Why would we want to do that? And we don't do that to other, we wouldn't do that to any other business similarly. And so I would just want to make sure that we apply whatever standard to everybody across the board. I think what Senator Guthers is attempting to do is extremely reasonable, because this amendment that we just passed does not automatically give them the permit for that municipal solid waste landfill. It simply satisfies the requirement and builds upon what was laid out in 2395 and clears up any ambiguity. And so Senator Guthers' amendment simply does something that's already going to be required pursuant to the Guam Solid Waste Management Rules and Regulations. If a member believes that that public hearing is not required, then fine, I would support restating it just so that we're abundantly sure that they're going to get that public hearing. But if we're going to go with the original amendment, which says, or other government or autonomous agency approval, we just went through 6 weeks of an administrative hearing where you have the current administrator of EPA that is just so hell-bent on having this landfill in that area because of what was admitted to be a conflict of interest. So I would support Senator Guthers' amendment. If it does not pass, then I would object to the main amendment as originally offered.
Okay. On the Guthers amendment of the Pangilinan amendment, are there any other speakers? Okay, if there are no other speakers, there was an objection raised on the Guthers amendment, so therefore all those in favor of the Guthers amendment, please raise your hand. All right, amendment fails. Okay, on the Pangilinan amendment, Senator Tenoyo.
Thank you, Mr. Chairman. Mr. Chairman, I did ask the mover of the original amendment with regards to who would conduct. So it says, notwithstanding any other provision of this section, a public hearing shall be held prior to the issuance of any permit or other government or autonomous agency approval of an application relative to the landfill. Do we want to distinguish who is going to conduct the public hearing? Because it kind of behooves us to say, well, EPA or DPW or the mayor's office. Who is going to be responsible for carrying it out? Is it just going to be, there shall be one and we'll figure out who's going to do it along the way?
Is that a question?
Question to the author.
Would the author yield to the question?
Thank you very much. The intent, of course, would be the agency for which the permit is submitted to. And so it would be the permitting for which the application, the recipient of the application. So agency approval of an application relative to the landfill on parcel B. So the recipient of the application is my intent there.
Yeah, I don't have a problem with having legal counsel make the corrective language so that the agency who has the responsibility of carrying out the permit or the lack of, or denying the permit shall be responsible for conducting the public hearing, unless you wanted to make the change, but that's the Fino English. I'm fine with the legal counsel. I'd like to move that amendment at this time, though.
Okay, there is an amendment sent to Jest. Can you repeat that again, Senator Tunay?
Just to be clear, just to authorize legal counsel make a technical correction, which in essence would say that the agency responsible for issuing or denying the permit shall conduct that public hearing as mandated in this amendment.
All right, are there no objections to the Tunay amendment? So ordered. Okay, we're back to the Pangilinan amendment. Senator Cabo.
Yeah, thank you very much, Mr. Chair. Mr. Chair, I rise in support of the Pangilinan amendment. I think it's so important, especially when we're discussing a type of development that deals with solid waste of this island. I know it's been a very controversial subject, just looking at the issues in regards to Lejon and how it's been such a long-standing issue with the people of Inarajan. I think it's just important, and again, I want to be very clear that in decisions made earlier in the body was my understanding that there would be a reaffirmation of a zoning designation that had already been identified and enacted in the past. Of course, I've had some discussions with some of my colleagues, and there is this difference of opinion, which of course I'm concerned as well. And with that, I think it's just so important that if there is this footprint and if it is expanded, that and even if the footprint was not expanded, if there is to be moving forward with a development of a subtitle D landfill or any other type of landfill, it's it has been many years since the original issuance of that particular zoning in that particular area, and the community has changed, the population has changed. I may be wrong, and I just say that's why, because I'm not too sure whether there has been an expansion. It's so important to allow for the public to participate in this process, because again, just as residents of Lejon have been very strong and forceful in their concerns about a landfill being built in that area, and many of our colleagues again have been a part of this issue and have been listening to the concerns of those individuals in Lejon, in Inarajan, and Malolo. The same consideration should also be given to the residents, and I'm not too sure where this area is, whether it's PT, Santa Rita, I'm not too sure. But wherever particular community that this proposed designation is to occur, I think it's just so important that if this if there was to be a movement forward for the application of a permit, that the people of that community and the people of Guam be given that opportunity. So I'm not trying to pick sides here, but I just think it's important, please, to my colleagues, this particular amendment, though I was in favor of the earlier amendment that failed, I'm also in favor of this amendment, and I'm asking all my colleagues here to be supportive of it. Thank you very much, Mr. Chair.
Thank you, Senator Calvo. Senator, Speaker Wampen, ma'am.
Thank you, Mr. Chairman. Mr. Chairman, sometimes I know when we try to amend or even write amendments, we try to make it as clear as we would like it to be, and sometimes it does not turn out that way. And sometimes maybe a simpler language maybe would work, because I know when this first came up and we started to just kind of casually talk about it, there was some agreement, and I'd like to go ahead and see, and I don't know if this would be proper at this point, but I'd like to amend it if I can, and I don't have it prepared, but I'm sure you'll be able to follow me. It's very simple. It's just to, in place of the word the, where the last sentence, relative to the, to put any, and then add the words municipal solid waste landfill, and then delete on partial B and to put down proposed for Guam. So it's any municipal solid waste landfill proposed for Guam.
Okay, point of information.
If you want me to write it down,
What is your
of
point of
course,
information? Can you go so that she can hear you, because she has a difficult time hearing, sir. There's a point of information by Senator.
Oh.
We're talking about the Senator Pangalinan's amendment. Is that where
Yes.
the amendment is occurring?
Yes, sir.
To amend the amendment? I'm trying to read here. It says, where would that fall in? Notwithstanding any other provision?
No, that would go into the last line.
Right, in the last line.
And-
But so it's not this that we're talking about then?
No.
We're talking about another,
Yeah, we're talking about this amendment.
this amendment is not yours?
Mr. Manalo?
Yeah, is she amending this or another one? That's what I'm saying.
Yeah.
So I can be on the same spreadsheet. So, Madam Speaker, this is the amendment that you're trying to amend?
Yes. and
Okay, because I was trying to read it. Can you
on the last,
restate it
on
again?
the last line where it says of an application relative to is any, remove the, put any, and add municipal solid waste landfill, then delete on partial B and said any landfill then proposed for Guam. So the last one, the last sentence, line would read, of any application relative to any municipal solid waste landfill proposed for Guam.
Senator Shimizu?
I have no objection to it. I just
Okay.
wanted to speak on it.
Okay, on the one-pad amendment to the Pangilinan amendment. Is there any discussion, any objections? No objections, so ordered. Okay, we're still back at the Pangilinan amendment as amended. Senator Shimizu.
Oh, okay. Thank you. This basically, what it does is that before any approval, we've got to have another public hearing on this particular spot of partial B. I'm trying to see, because it makes reference to the lot numbers on top. Okay, earlier to this, I can't find that. So you're deleting on partial B, so it doesn't make any reference to what we had talked about earlier. So then this has to be most recent amendment of BJC. That this is, yeah. So any so would that also be applicable to the Legion? Do they have to go all the way back again to the Legion, because the first time around was just to do a recommendation and a selection and what's that and then also to, well, you know, let me just say that the process that they're doing under Legion is very different than the process, as I saw it, that's being given to the other proposed landfill, being that for example, you know, we've already spent so much money in there, and then now we decide that we needed to go in there and put a road in there. We didn't get the permit. They put the road, it eroded. There's no there. We went in there and spent $11.5 million plus the $4.5 million, and they said, oh, by the way, we better go and condemn those property to an eminent domain, and then, you know, now we say, oh, wait a minute, we got to go and go back and go and do the zoning. Oh, yeah, we got to go back and do the zoning. And as you know, we had met with the Attorney General because the citizen volunteers of the TLUC had a chilling effect in terms of a letter that came to them that, hey, look, the action that you take or the failure to take any action, it can be viewed as, to some extent, I don't know what degree of contempt as a result. So all of that has occurred is now already in the hands of the federal receiver. I mean, the judge made it very, very clear that anybody who tries to delay this and so forth, I mean, it's in the court, and we can get it out and read it again, you know, to impede the progress of this thing. Again, might be, including the senators, will be held in contempt. You know, like I said, it's a very chilling effect. I still believe I'm you know, under the red, white, and blue and so forth. But those kinds of comments that have gone to the TLEC, those kinds of written pronouncements and orders and directives does have a chilling effect even to this body. So looking at this, to say, okay, let's start all over, tabula rasa, you know, in the beginning, we're all going to go all the way back, and we're going to have a public hearing. You know, and my concern here is we go all the way back, and then again we get hit on the supremacy clauses. As you know, a supremacy clause has been hit on this body on a piece of legislation that basically stated that no funds shall be expended on any properties that is not owned by the government. Well, the supremacy clause says no. That's going to slow down this process, and by the power of the federal government under the supremacy clause, that's not going to happen. So your legislation, you know, is inferior to the superior supremacy of the federal government. So then again, looking at this, am I to understand that we're now going to go and as if that doesn't exist, those experiences was never invoked on us, and say we're going to start. So we all know that in terms of landfill, there's only so many square footage in design. There's only two that is popping up in the island, and that's in Lejon, and of course what we had just spent a lengthy time on the issue of the partial B. So I mentioned this as a cautionary thing, and I agree that they should have the public hearing upon that. But the public hearing that we had at Lejon was to give the committee input and people input on which one are they going to select. So now this one is before any permit. Now, is that saying that Lejon already has a permit? If Lejon already has a permit, then this has no force and effect. From what I learned today was that the private enterprise is in the process of getting those permits, but there have been a number of flags that were raised as a result of whether it's zoned M1 or is it still zone A. Senator B.J. Cruz came in with that amendment, and we had a lengthy discussion, which basically got the confirmation from land management. Said if you get it the way the language is written, although it be in a zone A, it's a permitted use. You know, so it'll be okay. Then they'll be able to clear that application, and so forth and so forth and so forth. Now, if that amendment that we put in earlier this is going to say, well, it don't matter on the zoning of the permitted use. It don't matter. You may be permitted to use that there, but it still don't matter. You have to go and again start from ground zero, go, step back again, and have those have a public hearing. And then again, if the administration or whoever is supposed to conduct this public hearing say, well, yeah, we're supposed to conduct a public hearing, we'll just conduct it in the next 10 years, on this side of the application versus that of the application. So then again, I look at this as, other than saying that, yes, we must have all the public hearing, from what I gathered, there was I don't know if it's a town hall meeting down in that area where they discussed the pros and cons. And of course, it doesn't show as an official public hearing. But I stand in opposition to this amendment, basically because of the fact that, we're going to show again that district court that again you're just trying to put in some of these conditions that will try to delay us and so forth. And already seeing this body hit, and I really try to protect. I mean, I'm jealous about the what the people of Guam has entrusted to us, only to be told that don't count. So I just wanted to raise that concern. It's happened earlier, and I don't want to go through that process again. And thank you for your patience, Mr. Chairman.
Thank you, Senator Shimizu. Senator Tenorio on the Pangilinan amendment as amended.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to say a couple things here real quick. First of all, I think that what we're doing is kind of doing what we do in legislation many times, being redundant. I think what the gentleman's attempt here to do is to say that, with all the things you need to do, you need to make sure that you talk to the people in that neighborhood before you put this in. And, of course, the redundancy part of it is, I think, is probably somewhere else in another section of law. That being said, I think we also made a couple of amendments saying that if you're going to be going through the permitting process and you're receiving that permit, you should carry out that public hearing with those same constituents, the people who live in that area, the people who are going to be affected by this. And therein lies the redundancy. So what harm comes from it? I don't know. I don't see any. Is it going to be another roadblock? I doubt it. If it's going to be permitted, they're going to have to get public input anyway. So what's the resistance? I don't understand. I don't like to be redundant. I know we do it many times in legislation. Is there any harm by saying we should get public input? I don't think so. I think that's ultimately probably the single most important point that could be reiterated in any piece of legislation. But that notwithstanding, we've put a certain number of mechanisms in this amendment, which means that, hey, go talk to them and see what they have to say and take it into consideration before you finally get the permit. Is that unreasonable? I don't think so. I don't understand the resistance. But myself, personally, I think it's a reasonable assertion to say that we should have the public hearing. I think the agency is going to have it anyway. So then begs the other question, if it fails, does it do any harm? No, I think it might actually do some harm, because it's a clear statement in this measure that since there's been some movement with respect to the location of Guatali in regards to this area or versus that area, this parcel, that parcel, we want it to be emphatic that you shall conduct this public hearing, and the public hearing shall take into consideration those things that people in that vicinity, in that neighborhood, want to say. And you have to give them that venue. So, I asked my colleagues, it looks like this thing is going to go down in a ball of fire, but ultimately, look at this thing objectively, really. I've given a little bit on the other side. Nobody likes to deal with this Guatali issue because of its long, contentious nature. You know, we've dealt with a lot of things, and I've heard a lot of, I was reluctant to even vote on the earlier amendment. But at the end of it, it seemed reasonable, given all the information that was given to us. So I supported that. And I don't want my actions to ever be construed to be a block to taking care of the federal responsibilities we have now, because this government, in every, or almost every aspect of it, has been one hurdle after another hurdle after another hurdle. Look at the, what is it, the 23rd legislature, 2395? Talked about in its legislative findings even. Notwithstanding its best efforts, hasn't been able to deal with the dump. The 23rd legislature, this is the 29th legislature, 12 years ago, that was passed. What was it? I think it was about 12 years ago. We're still there. And I don't want to have my fingerprint, my DNA, or my signature attached to anything that's ultimately going to be viewed as a bar to getting what needs to be done. We're going to be paying a lot of money, not just from this measure, but in the future, to take care of what we should have taken care of a long time ago. 20 years of festering this problem. And so this seems like a reasonable compromise, folks. Public hearing? We should have a public hearing and should be given the opportunity to talk about it. Now, I don't want to put anybody's fears to rest right now, that if there's another option for someone and we can get another sanitary landfill built somewhere that's going to take care of some of the problems, so we don't have to pay too much on one side, maybe it'll help alleviate some of the demand or help alleviate some of the costs associated with this landfill, we should do it. I think we should do it for all of our people. And whether you get past the personalities and you start legislating according to policy, we actually might get something done. So, you know, I ask my colleagues, look at this thing objectively. Be reasonable. Is it unreasonable to have a public hearing? And the agency's already got the requirement anyway? So, Mr. Chairman, I ask my colleagues, look at this thing a little bit more pragmatically, and let's move the bars to having what we already know should be in place, and let the democratic and the public process for input continue as it should be. Thank you, Mr. Chairman.
Thank you, Senator Tenoyo. Okay, there being no other speakers on the Pangilinan Amendment as amended, and there be an objection to the amendment, all those in favor of the Pangilinan Amendment, please raise your right hand. Please raise your hand. Okay, amendment fails. Senator Pangilinan.
No, the amendment. Thank you very much, Mr. Chairman. Mr. Chairman, you know, it's no secret, of course, that the issue of this landfill is tied to the issue of the incinerator, and I've been fighting this battle for years, and we've won some and lost some, and we continue to fight it. We're just about done. So it's not, I'm just wary whenever things come through this body, trying to push this issue along, and I try to ensure that I protect, you know, and what I think I'm doing is protecting the interests of the people out there from a contract that I thought is just a sweetheart deal as it relates to the cost that it would have placed on the people of Guam and the risk that it placed to the health and the environment of the people of Guam. So it's no secret. And so I'm always wary when things like this get moved along like this. So, and I always think that there's another door somewhere. And I see one door that exists, at least with this, and I'd like to be able to close it with the amendment I'm offering. The issue was, you know, they were trying to do, the amendment was placed because they basically didn't want to go to land management to rezone the property. They could have decided that no matter what the law says, they had parcel B and they could have gone in and applied to rezone it. I think what we did today negates any need to go in and rezone the property now. Otherwise, they would have had to go in, file their application to rezone the property from A to M1 to allow for the use of a landfill on that site. But what we did today, I'm pretty sure that we've rezoned this property now from A to M1, or at least we have allowed a landfill to be a permitted use in parcel B of lot 439-R1. And therefore, you don't need to rezone it because this legislature, in its action today, not in its action in 2395. The action in 2395 is not the same action that's happening today here. We started out with saying that we were going to reaffirm that, but it is very clear that the Department of Land Management's position and the facts present this, that the rezoning of the property for 439, as it occurred in 1969, was a portion of lot 439 that is owned by Gorco. So the remaining property after Gorco severed its lot, after it purchased a portion of lot 439, and then it put in its land registration, and it put in its rezoning application, was able to get an M2 zone on the portion of the lot that they owned in 439. So the remaining lot after you sever Gorco's lot from the basic lot is 439-R1. And the zone on that property is agriculture. That's why land management's saying, I'm not going to give you a permit or certify that you can build a landfill in lot 4, parcel B of 439-R1 because it's zone agriculture and you have to come in and rezone the property. And if you take a look at what is a permitted use under agricultural zone property, a landfill is not allowed. So what this body said is that we are now placing a landfill as a permitted use in an A zone lot B or parcel B 439-R1. So we have actually allowed a permitted use. So now they don't have to go in and rezone it. I also want to make sure that the other avenue that is available to rezone this without any public input is contained in subsection 60107, chapter 60, title 21 GCA. In that section, Mr. Chair, it allows the department, which is land management, the director, to basically have the power and the duty to survey, plat, inventory, classify, and from time to time reclassify all government real property. The department may use the following categories for such classifications: A, urban land; B, suburban land; C, agricultural land; D, grazing land; and here's the kicker, E, industrial and commercial sites; F, forest; G, wasteland, which may include land not classified in any other category. So, if the argument is that, and again, it's because of this, just what I've classified in the beginning as a sweetheart deal on the incinerator contract, which is how they got this property from the Chamorro Land Trust by the virtue of the incinerator contract. That's how they got it. That's how they're able to take this Chamorro Land Trust property and lease it out, because they have a right to lease property for a landfill under the incinerator contract, which has already been declared null and void by the courts. Yet we're coming back in here and now saying no matter what your right was under that incinerator contract, I think, in my opinion, but again, it's still up for contention for the final resolution of this issue, is that they went and under that contract got a lease from the Chamorro Land Trust for this property to build a landfill. And now they want to be able to put in, to not have to rezone it. And that's exactly what this body did today. But just in case they don't have to do that, they can go to the director or the department, and he can, without a public hearing here, just reclassify that property. It's government land under lease, so they can do it without any hearing. And again, I want to close that door. I want the public to know that if these guys are going to move forward on that thing and so forth, even though we've already, in my opinion, allowed that permitted use there and obviated the need for a hearing by just what we did, I want to close that door and say no matter what, you can't reclassify this property at least and just have a wide open door instead of a double door instead of a single door, because this we have given them a door, and if we don't close this door, they're going to have a double door in terms of just do what they want down there without regard to the neighbors, et cetera, et cetera. So I would like to amend and present my amendment that says that and add, again, a new section to the section added by the B.J. Cruz amendment, that the power of the department to reclassify all government land, real property in subsection 601-107, Chapter 60, Title 21 GCA, shall not be applicable to Parcel B, Lot 439-R1.
On the amendment, offered by Senator Pangilinan, Senator Shimizu.
Can we just get a 1 minute recess so I can
Let's take a 1 minute.
articulate a copy of that?
Let's take a
then?
1 minute
Can I
recess.
just get a copy of that, or is it here already? Do we have it here? The one that you just, yeah, can we just get a copy of that? I have Gutter's. Can we have the speaker over here, please, out
Okay,
of the
the
gallery
committee
of
will
the
back in
media,
order.
so she can listen? No, seriously.
Senator Shimizu.
I want to see all the other senators come back in here. Thank you, Ray. Good. Mr. Chairman, I stand in opposition to my good colleague of Barrigada as amendment, ostensibly because I have no problems with public hearings and doing all of that. I mentioned earlier how this is going to be viewed. That motion fell. Now he wants to come over and he explained it to me by what he has spoken, that this amendment will ostensibly give the director of land management broader powers on any government of Guam land, that he can just join it by his own personal authority. I mean, he can go right in any government of Guam land, say, and change it from agricultural to commercial or to M1 to or any or PUC, PUD, whatever the case may be, except where there is. This is where I asked earlier, and I'm saying it within it in a discriminatory way, that it says you can do all of that in any of the government land, but once it says a landfill, then the powers of the director no longer exist. So he's able to pick and choose. That you can do anything, the power you can have. In fact, he has the power without even the public hearing. Without the public hearing, he can go to any other government of Guam land and say, M1 by my power, M2 by my power, PUD by my power. No public hearing on that. That's my understanding what this amendment will do. He can do that without any public hearing. You know, we have the TLUC, and whenever we have an M2, such as what they have in Gorko, which have been very, very explosive, and it happened during Pangsangwa. So then if it's a government property, the director can say, never mind that, all that public hearing and all that transparency. This is what this amendment would do, as explained by the good author, my good colleague. Now we all know, he by his preface, that he has been against this quote unquote sweetheart of a deal. I've attended a number of briefings, and I try to come with objectivity. I've attended a number of briefings that was presented by the proponent of this landfill, even the cost and so forth, because that's what I think earlier I understood it to be, that this is going to be so costly. But you know, Mr. Chairman, as I look at the other one with that was presented to us on the briefing, I can't believe it. We can't even pay the tipping fee of $10, and I think they're proposing like somewhere around 34. And that's just the basic. That's the generic. Then there's another one, and then another one, but they did not put in that document, because I asked the question, does the court knows about what this will cost and so forth? So no, we haven't put that in, but definitely I'm going to tell you, you bundle all of that up, it's going to come up over 100, I don't know, 154 or something like that. Memory might not serve me right, but it's around that ballpark. So when we get to that, and if that's a sweetheart deal, as it looks as to what's it going to cost the people of Guam, then I'm asking myself, what if it's almost the same? Hello, sweetheart, or hello or goodbye, sweetheart, because whether you like it or not, sweetheart, it's going to happen. Whether this legislative body says, you know, we're going to enact legislation, it's going to happen that way. And then on top of it, the issues that he mentioned earlier in terms of the litigation, it's been for many years. And I think they're on the verge of resolving it once and for all. I don't know which way it's going to tip. But be it as it may, just the amendment, what it's going to do is, I was looking at it, he wants to close the door. I think that's what I heard earlier. I think this is slamming the door. in a sense, because it discriminates. I mean, this is absolutely slamming down. And I looked at it earlier that he's very upfront with it, and I'm very upfront also that I don't believe that Lejon is the best place. I believe it should be in an area that has been zoned. The neighborhood, the same property has been zoned in that area. And again, we did mention on the survey map, it indicated that notes, and then, well, 13 years later, I'm not 13, 7 years later, representatives of land management say, well, it's not in our zoning file, but so is a lot of other stuff that's not in there. So there's that possibility, and they did accept that. So I have to commend my colleague coming up with many creative ways to be able to stop that project. But I'm just at loss. And then but then I ask myself on the economic side, what's that? Their private enterprise is going to. I'm sorry. What was that, please? Oh, okay. Thank you. So I do stand in opposition to this, simply not because I want it there, because the motivations is an intent is that I'm going to close that door. I don't want it there. That's why, because I believe in, and he has stated his reasons. The reason for the ecological issues, the issues of this is a sweetheart deal. But boy, I tell you, when I look at at some point in time, this community is going to have to start addressing the issue of an integrated system, because let me tell you, you have to try to deal with reducing the waste at some point in time, but not every waste that we have here is a good candidate for recycling, a good candidate for composting. There are some of those that needs to be addressed to reduce the waste given the technology that we have today. And I have gone and visited other integrated solid waste project, and that was 13 years ago that I've attended different places to see what other jurisdiction has done in that area, and they're landlocked. Here we are surrounded by the trade winds. So my objection is based upon we should not come up with statutes that are discriminatory in nature, and that personal preference are, I guess, allowable if you can get a consensus amongst everybody. So for that, Mr. Chairman, I can go on this, but I will just for purposes to object to this amendment. Thank you, Mr. Chairman.
Thank you, Senator Pangilinan. Okay, are there any other speakers to the Pangilinan amendment? Okay, there be no other speakers on the Pangilinan amendment. There has been an objection to the Pangilinan amendment. All those in favor of the Pangilinan amendment, please raise your hand. There's been an objection, so I call for the vote. Okay. Amendment fails. Are there anything else? Okay, let's take a 30-second recess, please. Okay, committee hold back in order. Speaker Wampet.
Thank you, Mr. Chairman. Mr. Chairman, yes, I do have an amendment. I hope you can find them now, the piles of amendments. And it's actually, now I can't find mine. It's two paragraphs, and therefore the Commission on Decolonization and the Chamorro Land Trust Commission, yes. And what this actually would do is that it's going to make it consistent for all of the commissions in terms of including the inclusion of when they're going to actually meet, and the dates that we the days that we have here and the times are actually the times in which currently they have set for themselves, but they have not actually have been meeting. And to my understanding is that in particular with the Commission on Decolonization is that, and what we did is we went ahead and confirmed everybody, but somehow they're just not meeting, and the requirement now is that in the absence of a quorum, that minutes will be prepared by the director of the commission indicating a lack of a quorum, the date, and the members in attendance, and then submit that to the governor and the legislature notices of that, so that action can be taken then, whether they need to replace these individuals who don't want to show up. The other is, in the Chamorro Land Trust, is to actually set, this is the time frame in which they normally would meet to. The problem, however, is that they have not met, and we did the exact same thing. We confirmed every single member. They have not met. There's about 140 right now outstanding, requests for lease for commercial properties, and they know they're in dire need of money, and money comes based primarily from those leases, and there's 140, but they've said that they couldn't even act on it themselves because they never have meetings. So what this would do is actually stipulate or mandate that there be those specific day of each month and a time in which they're supposed to meet, and also to indicate again the same thing if there is an absence and what of a quorum, what to do in the absence also of the chairperson and the vice chairperson. So I hope my colleagues would support this.
Thank you. The amendment proffered by Speaker Wampats, Vice Speaker Shimizu.
Would my good speaker yield, please, to a question?
Madam Speaker, would you yield to a question? What's your question?
My question is, when was the last time they met? How chronic are they?
For the Commission on Decolonization, actually they haven't even met for a year.
Right.
Over a year already. The Chamorro Land Trust.
And who's the chair on that?
That is by law the governor.
The governor. So we're gonna say, Governor, you're out if you don't attend so many meetings. Is that basically what you're doing?
No, that doesn't say that.
Okay.
Not in that case. It's in absence of the chairman and the vice chairperson, and then the quorum of the members will select an acting chairperson at least, so that then the meeting, they'll be able to have a meeting.
Okay, on that one, I'm still discussing it, so I'm still thinking about whether I'm going to object or not. So we have two parts here. Number one is dealing with the Chamorro Land Trust. That's basically the question I wanted to find out. When was the last time the Chamorro Land Trust? Because we're singling out one commission. This amendment might be good all across the board. The commission shall meet regularly on the first Tuesday, so we're telling them when to meet and at what time to meet. So if they weren't able to meet at start at 3 o'clock, then they can't do anything, because we've mandated in statute, and more often is determined by the chairperson or by the chairperson of the commission. Is the first one the Chamorro Land Trust on top?
No.
That's the commission on self. So is the second one. So at 1 p.m. and more often is determined by chairman. At the first meeting, the commission shall select, and they've done all of that. The problem is they're not been having meetings or called meetings by the chairman, as I understood it. Any appointed member of the commission, which is the Chamorro Land Trust, who fails to attend 3 consecutive regular meetings without being excused pursuant to a motion passed by the commission, shall automatically be disqualified to continue serving in his or her position, and the appointing authority shall be required to appoint. So the appointing authority here is the one that's going to give him an excuse note. Got to bring an excuse note over to the commission. So here's my excuse note without being excused, pursuant to a motion passed by the commission. So the commission can say, well, you've been out for 6 times, but we'll excuse you. and so this shall automatically be disqualified if they've already went ahead and got excused. I spoke to the good chair, and then I just picked up the phone and I called up the chairman of the Chamorro Land Trust Commission, and I just want to read a letter that I sent to him after my discussion with him, because there have been constituents that have been trying to get to the Chamorro Land Trust to deal with their application. I just say, dear Mr. Chairman of the Chamorro Land Trust Commission, thank you for agreeing to schedule a Chamorro Land Trust Board meeting in the first week of December. As you know, many of the pending commercial leases have the potential of providing our people jobs and commerce to provide economic growth. I also thank you for agreeing to have an application to be placed on the agenda and heard by the entire board of the Chamorro Land Trust Commission. After 2 years, this applicant, after 2 years, I feel it should have its day before the body and bring a resolution to the issue. While I see so many businesses from the outside receive approval and benefits from our community, I feel we should support the local people in their ventures, especially ones that reflect the value of our culture. Should it be approved, it would raise the level of the Chamorro Land Trust Commission land leases and the value of its resources. And I close it by saying, I wish you and the board well as you deliberate the pros and cons of this issue, should you have any question. And the reason for that, it takes a senator to write these kinds of letters on constituents that come in here. And it takes the chairperson who has oversight of that and say, enough is enough. I am going to legislate. I'm going to tell you that you must meet every third Monday at 1 p.m. Now, that's very, very clear. They can come up and say, well, you know, we didn't make it by 1 p.m., so we can't start the meeting. And then on top of that, it can go and get excuses for not being able to have the meeting. So that's why I asked this question. It's taking this body drastic measures in this legislation to force the Chamorro Land Trust Commission to be more proactive and responsive in carrying out their duties and responsibilities to have regular monthly meetings to deliberate on all the applications that people have put in. And that to come to this body, you know, even after we had confirmed, we went through the confirmation process of most of these people. And that has been one of the things that was brought up. Will you be diligent in carrying out your responsibility? Obviously, what has prompted the chairperson and the speaker, nonetheless, is to put in this amendment. To put in this amendment, something is wrong where we have to do this. The punitive part of this, again, they were going to say that they become disqualified, and we have to go through all of that process again to get a quorum. You know, I don't know. I think maybe what could be, I'm not objecting to this amendment. Let me make that perfectly clear. However, I think we can do some due diligence by having either a round table or bringing them in on an oversight. I would prefer the oversight and swear as to why they're not having this meeting. There must be some legitimate reason. Because if we in this body believe that there's no legitimate reason, then there is some illegitimate reasons. Is it to block application? I don't think so. I know Oscar, and I know the members of those board. So when I spoke to him, he said, Mr. Chairman and Mr. Vice Speaker, I am having a meeting in the first week of December. You know, but I don't know. I don't have the oversight of that agency. But I wondered, when was the last time they met? Because if our memory serves me right, we just confirmed them. We just had a round table. We just had the round table. I'm not objecting to this, but I still like to know, you know, what's happening. I mean, maybe the oversight would be able to let us know. Like I said, how chronic is it? Is it the past 6 months? Is it the past year? Or, you know, just how chronic? For my information, I'm not objecting to this, but I surely like to know what it is because I just picked up the phone and I talked to the gentleman. And he assured me. So what I've done is I memorialized the letter, and I will hold him accountable to his word to me. So I'm just saying, while I do not object to it, it might be a little bit more drastic. And again, it's discriminatory. There are some other boards that are probably not meeting, but we single out only the Chamorro Land Trust. Maybe we should make this generic. That all those boards that we have out there, if they haven't been doing their due diligence and they have not been attending, then they'll automatically do that. That's going to be a problem. So, Madam, Mr. Chairman, thank you for at least letting me speak on that, because I don't know when was the last time they communicated, this body or the oversight communicated directly with the chairman. I just did, and Senator Barnes was right there with me. Right? I picked up the phone and I called them, and there is going to be. So I was not aware of this amendment until Senator Barnes had told me about it. So I said, pick up the phone and talk to these people, and see what we can get, because it needs to be addressed at least in that part before we just slam. We're gonna force the will of the legislature. But I would trust the good chair that this is the gentle persuasion versus that of the radical strong arm of this body, and only singling out the Chamorro Land Trust. Thank you.
Thank you, Vice Speaker Shimizu. On the Wampat amendment, Speaker Wampat.
Thank you, Mr. Chairman. I appreciate, the foundation laid by the Vice Speaker, and I appreciate, of course, the fact that he's, used his persuasion to speak to the chairperson, then to actually, hold this board meeting. And Mr. Chairman, what I like to also quote for you is that what's listed here is not necessarily only to the commission itself, but the language is actually is consistent with the other commissions. And just to give you the exact language that's actually used in the Commission on Decolonization, where it says, any appointed member of the commission who fails to attend without being excused pursuant to a motion passed by the commission, 3 consecutive regular scheduled meetings shall automatically be disqualified to continue serving. So it's not as if though it is only one commission that we're trying to single out here. And granted, yes, sometimes when we do call, and we've seen that happen, is that when senators actually call, they respond. They respond by coming to the meetings. They respond by responding to our questions. They respond by conducting then public hearings. It was at the request of so many applicants to the Chamorro Land Trust who have felt that their applications, their requests have all gone to deaf ears. And Senator B.J. Cruz and Speaker Ben, had requested that we do an oversight, because our senators are just being bombarded with so many complaints because the board has not taken any action. And granted, one of the maybe reasons in which they're not able to have a board meeting is because they didn't have all of the commissioners in place. And I quickly submitted a letter to the governor requesting that he then appoint individuals so that the commission can go on with the business of, reviewing all the applications and making decisions on any of the leases. And since then, they've all been appointed, and it's been months already that they've been appointed. And to date, there hasn't been this meeting. And granted, I don't like the idea, of course, of having to mandate this. It is actually mandated for them to meet the specific date and time. Was actually their times that they have set. And Mr. Chairman, I prefer, of course, not to do this. And maybe then, since, in good faith, for us to believe that they are going to go ahead then and conduct, this meeting in December, so be it then. And I'd be willing to go ahead and withdraw this amendment. I know my colleagues are laughing at me because in January, I know it sounds like what we did the last time, but because in January is that then if, the new chairman, I'm going to count the chairman now here, the new chairman to hold them, their feet to the fire, and if they don't, I'll reintroduce that amendment again myself. Unless, wait, I didn't even ask my second co-sponsor. Okay, I'll defer to my my co-sponsor.
Mr. Chair, if I may, just based on that presentation by the author of the legislation, asking her to reconsider this proposed amendment, and I say that with all sincerity, is because as we look at the commissions that are in fact, we have, and I'm not going to deny that I haven't, that constituents have not come into my office to say that they're concerned that they've turned applications in and they've been patiently waiting, not for days, not for months, but for years. And I'm just saying that if the holdup is going to be because the commission is not meeting, then I think that sometimes you've just got to put to add fuel to the fire. You've got to be able to make them accountable for, and this is maybe one way that we can realistically look. So I'm asking the good author, just keep the amendment and see if it would be supported on the floor. And because I really support this amendment, and I thank her for carrying out on this amendment as an oversight, but I think it's important that we continue to hear the outcries of our constituents out there who come in to see us, and I think that this is one way of at least telling the commissions that they've got to do their work. In the past, there was concerns about them not being able to perform their due diligence or work the mandate for what that's presented before them, is because there was a lack of quorum. This time there is a quorum, and we've been diligent on our part to make sure that when those confirmations or those appointees come down, that we hear it right on time and vote on it so that these guys can continue to work on the mandates that are really needed for our community out there. So I ask that my colleagues support this amendment, and I thank the good author for keeping this amendment in. Mr. Chair.
Thank you, Senator Muñoz Barnes. On the Speaker Wonpat, Senator Muñoz Barnes amendment. Speaker Pangilinan.
Just real quick, Mr. Chair, this amendment really isn't as punitive as it seems. Actually, it could be a good planning tool for the members of the commission. And it's not unusual. We actually have the provision about the attendance in other boards. It's a general law that's out there. We even have a law that says if a commission fails to meet within 6 consecutive meetings or something, then obviously it's not needed and it's abolished. And then you examine again whether you need to reconstitute that or merge it with another commission and so forth. So this could provide a real good planning tool for the members of the commission. They know when the meeting occurs. They know to plan to be there. They know to plan to work on the issues that are and the agenda that's before them. You actually have other commissions and regulatory bodies in the government of Guam that are actually, whose meeting times are set by statute, that they have a regular meeting on the 3rd Thursday of the month or so forth. So it's not unprecedented. And you'll find that where that exists, you'll see that things get pushed through there. Maybe not perfectly, but certainly the majority of the time. So I just want to say that I don't think it's meant to be punitive. I think it's meant to assist the commission in planning for those meetings, ensuring that the members know when they're expected to attend and adjust their schedules accordingly. It also allows new nominees to actually make a determination up front whether or not they're going to be able to devote the time, given exactly when the meetings are, to devote that time to serving on the commission. They can make that decision on the onset rather than being appointed and then not being able to make the meetings. So I think it's an okay amendment. Thank you.
Thank you, Senator Pangilinan. And on the Juan Pat Munya Barnes amendment, okay, there be no more speakers, okay, no objections. So ordered. Is there any?
I do have one more amendment. Yes, but I do have
Speaker Juan Pat.
I have one more amendment, and I thank my Speaker Ben for bringing this to my attention because we've been here all day and I haven't even been in my office. But if you recall, we had authorized GPA to go out and get a loan, a $10 million loan. And in the process of doing this for their capital improvement projects, they ran into some problems with the bank in finalizing the loan. And the bank has asked for a waiver of sovereign immunity and tax payments similar to the waivers that were afforded the bank earlier this year. And so there is an amendment, but it's being Xeroxed currently. I know that's the reason why I'm just kind of saying this, and then I'll show you the amendment. So, but that's the request is actually coming from GPA that we needed to give them the waiver. So if unless anyone wants to talk about it, the amendment is on its way. Or if you want to take a minute recess.
Okay, let's take a minute recess. Okay, the committee hold back in order. Speaker Juan Pat, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, you should have a copy of the amendment, and it's to add a new section 16C and 16D is hereby added to section 8 of Public Law 29-82 to read as follows. And that will be a new subsection. I'm sorry. It's only going to be C, so rather than the D. So it's 16C. And it's going to be notwithstanding any substantive or procedural provisions of Chapter 6 of Title 5 of the Guam Code annotated, the government of Guam hereby waives immunity from any suit or action in contract on the loan but does not waive sovereignty immunity as to the personal liability of elected or appointed officials and employees of the government of Guam.
Okay, on the Wampat Pangilinan Amendment, are there any discussion? Okay, no discussions, any objections? No objections, so ordered. Senator Respicio?
Thank you very much, Ms. Chairman. If there's no further amendments to Bill 383, I move that we rise from the Committee of the Whole with all amendments made to Bill 383 while we're in the Committee of the Whole and with the recommendation to pass.
Okay, on the Respicio motion? No objections, so ordered.
The legislature is back in session. Senator Respicio, you're recognized.
Thank you very much, Madam Speaker. I move to place Bill 383 in the voting file.
On the motion to place Bill 383 in the voting file, are there any objections? Without any objections, so ordered.
Madam Speaker?
Yes, please continue.
May I be permitted to make a notwithstanding motion to revert back to motions?
On the motion, without any objections, so ordered.
Madam Speaker, I'm not entirely sure we'll get to these other bills, but there's been additional committee reports made, and I'd like to then place at the bottom of the second reading file Bill number 375. It deals with the Board of Accountancy. It's pretty timely. They weren't recognized in the FY 09 budget, but it's a special fund, so it's no additional revenue. Bill number 367. It's relative to creating incentives in the qualifying certificate program for the manufacture, distribution, and sale of alternative fuels and exempting such fuels from liquid fuel tax. And another committee report that we have is Bill 369 to correct the land for the landless projects in the ES subdivision. And the last bill, which the chairman and the author promised that we're definitely not going to be able to get to, but that it be at the bottom of the second reading file, Bill number 360, and it deals with, it's relative to the licensing and to obtain a special Guam cosmetology license, and that's that bill.
Okay, so on the motion then to place the following bills 375, 367, 369, and 360 at the bottom. The first one, yes. 375, 367, 369, and 360 on the bottom of the second reading file without objection, so ordered. Senator Respicio.
Thank you, Madam Speaker. Notwithstanding the House rules, I move to reorder the agenda to bring up the two resolutions and the Board of Accountancy. And then we'll try to get to the other.
Can we take a minute recess, please?
Yeah. Can I pull back the
fine, I'll pull one of mine up.
now, or do you want to continue the second reading?
We're back in session. Senator
Thank you,
Respicio.
Madam Speaker. Notwithstanding the House rules, I move to pull back 3 bills that are in the third reading file because they need to make very minor. Notwithstanding the House rules. Bill number 297, Bill number 272, and Bill number 378. And
Okay.
bring them back to the top of the second reading
on that
file.
motion then, to bring out these bills, 297, 272, and 378, back to the second reading file without objection, so ordered.
On the top of the second reading
On the
file.
top,
yeah.
yes, on the top of the second reading file. Okay, so then we're now then on the second reading. And okay, we are in second reading, so therefore the first bill that we have then is 297. No?
No, he has a technical.
No, this is a
Yes,
reconsideration.
the one that we brought
Yeah.
back is back in the second reading file, so
Yeah.
that's what I'm saying. So it's 297. Senator Tenorio, you are recognized.
Thank you, Madam Speaker. Madam Speaker, procedurally speaking, I move to place Bill number 297EC as substituted by the Committee on Finance, Taxation, Commerce, and Economic Development as further amended on the floor in the third reading. I'd like to make a quick amendment to the bill.
Okay, please proceed.
Madam Speaker, there was a contradiction in...
We can't hear.
Madam Speaker, there's a contradiction or conflict in Section 2, which deals with the effective date of the mechanics lien bill on page 1.
Gentlemen, please. I'm unable to hear the speaker.
Thank you, Madam Speaker. So the section which needs to be corrected are the same correction, and the legal counsel is prepared with the corrections already. I have spoken to both stakeholders and the lawyers for those stakeholders, and the effective date on this will be 60 days, and that will be on line 10 on page 1.
Can you give, yes, page 1? You said?
Page 1, line 10, under section 2. So strike out 180 days, and then the same exact language will replace the effective date on the very last page, 10, on line 12, where it says item 2, which is 2 I's, Roman numeral 2, within 30 days will be now within 60 days. And the reason for this is because of the 45 time limit in the notice requirement. We need to give adequate time, one, for those who are going to be involved in this process to be brought up to speed, and 60 days is reasonable for that. And number two, the 45-day limit fits nicely within that 60-day period as well. So this is agreeable to both Mr. Tarpley, Mr. Clark, and of course their respective stakeholders.
I want to make sure that the clerks have it and legal counsel as well. Okay, so on that motion, are there any objections? No objections, and so ordered.
Jesus Mosley, Madam Speaker.
Now move it down.
They already moved it.
No,
All you
down
have to do
two.
is act on the motion.
Okay, so on the motion then to place bill substituted by the author and on the floor to third reading without any objections, so ordered. We have Bill 272. The author.
Thank you, Madam Chair. Madam Chair, I'm requesting that we put this back on second reading so I can make a change.
It is.
Is there? Okay, thank you, Madam Chair.
To accept, to place so that, and you want to discuss it.
Yes, Madam Chair.
Okay, please.
Thank you very much. Madam Chair, I'd like to, this is on Bill 272, the initiative bill. In order to address some of the concerns expressed by my colleagues and representatives in the community, I'd like to move to delete Section 2 and Section 5 of Bill 272 as engrossed. Madam Chair, Section 2 basically reads, a new 17202 is hereby added to Chapter 17 of Title III Guam Code Annotated to read as follows. An initiative measure can only be placed on the ballot in an island-wide general election other than a primary election in which the election of the governor is on the ballot. I'd like to move to delete that section from the bill. First.
On that motion, to delete, okay, so it's to delete Section 2. Is that correct?
That's correct, Madam Chair. And then also...
wait, no.
Oh, yes, I'm sorry.
So is everybody able to follow? Yeah. More importantly, I need to make sure the clerks are able to follow. Okay, so Section 2 then, to delete.
Yes.
Without any objections? So ordered.
And the next item is to delete Section 5 of the bill, which reads 17204, Chapter 17 of Title 3, Guam Code Annotated, is hereby amended to read as follows. 17204, same majority required effective date. An initiative must be approved by 50% plus one of all voters who go to the polls to vote in the general election at which the initiative was placed on the ballot. Any initiative so approved by 50% plus one of all votes who go to the polls to vote and said the election shall take effect 60 days after the date in which the commission certifies the initiative has been passed. There's already existing guidelines, Madam Chair, so this is superfluous.
So that the motion then is to delete section 5.
Yes, Madam Chair. And then the,
One moment, we'll take care of that first.
thank you.
I'm sorry?
Okay.
As engrossed.
As engrossed.
Okay. One moment, we want to make sure we have the engrossed copy. Okay, I just want to really make sure that the clerks have the engrossed copy. So then, section 5, which is on page 3, line 9 and 10, right? Lines 9 and 10 to be deleted? Or all the way down to 17? Yes, all the way to 17. So it's 9 to 17. Yes, right? So it'll be page 3, lines 11 to 17, which is all of section 5. Is that
All of
correct?
section 5 on page 3, 11 to 17.
Yes, so on that motion then, without any objections, so ordered.
And then, Madam Chair, I have one last amendment. In section 3, to delete the word general
And that
from line 25.
line 25, so delete the word general.
Yeah. So that it would read, if an initiative measure is not approved by voters in any election, no initiative measure proposing a substantially similar or substantially related subject shall be submitted to voters for at least 3 years after the date of such election.
On that last amendment, okay,
Thank
to
you.
delete general without any objections, so ordered.
Thank you very much, Madam Speaker.
You're very welcome. The other bill, on the motion, I'm sorry, to place 272 then in the voting file without any objections, so ordered. We have Bill 373,
No, 378.
378, I'm sorry.
Thank you, Madam Speaker. I moved that I passed out copies of several amendments that needed to be made to the Guam First Commission bill, and these are suggestions made by our Legislative Council, and I think it's really important to close up any loops and with respect to who will be the point of contact to the military buildup, and that's what these duties and responsibilities outline. And so it's an amendment by R. Respicio, and it's just been passed out, so I move that this be accepted.
On the motion then to accept this new section,
No, after I do this, I'm going to make the motion. No, I'm amending it. After I do this, I'm going to make the motion to move it down.
but it's on, so you made the motion then? Okay, so you
I move to place Bill 378
Okay,
in the
so-
voting file. However, I have one amendment.
okay,
Third reading. Yeah.
yes, for third reading, okay, and you have an amendment, and the amendment is to add this
Subsection
section
2301. Yeah.
2301. On that motion then, without any objections, so ordered. Is that complete? 378?
On the motion to.
On the motion then to send it down to the voting file without any objections, so ordered. Two, three, oh, one. Is that correct?
So the next bill.
Wait. Any question? Okay, so okay, we are now on the second. We're still on the second reading file,
Oh, I thought,
and we have Bill 3. Wait, what's 3? What's wait 1 second. One minute recess, please.
you didn't reorder the second reading.
We will if we can't get to it, but we're going to try to get to all these other bills. They're just not, they're not controversial.
Oh, yeah.
No, we're not going to do the Namasan bill.
As soon as they finish in grocery. Yeah.
The legislature is back in session. We are on Bill 377. Speaker Ben Pangilinan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to move that Bill 377, it's in the second reading file. It's an act to authorize the Governor of Guam to pledge compact impact funds for the construction cost of a new landfill. Again, this is just another option that will be presented to the governor so that he can have as many options. He sent down 2 options, but basically 1, and we've provided him other options, and this would be an option that would not impact the general fund, as I mentioned in the past, and it would authorize him to pledge compact impact funds for the construction of the landfill so that he can use the cash flow from the compact impact in conjunction with any other funding plan that we ultimately submit to the court to pay for the cost of the construction. So the bill is fairly simple, and it says, notwithstanding any other provision of law, Legislature Guam hereby authorizes the pledge of all remaining and unencumbered or unpledged current or future compact impact funds for the cost of construction and financing of the new landfill. And the reason why we say unencumbered and unpledged is we do know that there has been encumbered and pledged about $7 million of the compact impact for the new schools, but all the remaining balance of which is at this time 14 and will be subject to the adjustment later on based upon the census, that he's free to pledge those on a long-term basis towards the cost of the construction of a new landfill.
No objection.
Okay, are there any objections then in the motion to rather send Bill 377 EC to the voting file without any objections? So ordered. Okay, we have Resolution 199. Senator Guthrie, you're recognized.
Next one is 340.
They didn't reorder it, did they?
Next one is
No.
340.
Yeah, 340 is next.
No, I didn't make a motion because you said let's just get through the agenda.
Yeah.
Madam Speaker, if I may beg, notwithstanding the agenda's order, I'd like to move that we just skip 340. This committee report's been done and is being circulated at this time. And I'd like to, unless the body wishes to discuss it without the committee report filed, but we do have the committee report, it's complete, and we are circulating it. And so maybe we just skip it and go to the next bill, and when the committee report is finally presented, then we just go back to 340 and address it. So
Okay.
that's a motion notwithstanding the order of the agenda and the House rules.
Okay, so on
That's already a standing
that motion,
Okay.
then what?
All right. Okay,
Or
thank
earlier,
you.
that's right. They're not ready yet. We would
Okay.
skip it and then go right
Go
back
back
to
when
it.
it's
And
ready.
it would not lose its place.
Thank you very much.
So we will continue then with Resolution 199.
Oh, take it back. I'm done already. Here's your mama.
Thank you, Madam Chair. Madam Chair, Resolution 199 is relative to endorsing the Strategic Development Plan for the establishment of the Micronesian Center for a Sustainable Future and Administrative Research and Development Center for the Micronesian Chief Executive Summit and the Micronesian President's Summit. As you know, we previously passed a resolution in
You're
this
making a
legislature.
motion to
Yeah, I'd like to
accept-
move it for discussion, Madam Chair.
No, to accept resolution.
And to accept,
To accept.
Bri-
It's
very
not-
brief
It's
discussion.
not substituted, so to
Yeah.
accept then,
thank you very much.
199,
Wait a minute.
Oh, it was passed out already.
resolution, it's not a
Yesterday it
bill.
was passed out.
Madam Speaker, I don't believe 199 has been substituted, has it?
No.
So it doesn't need to be accepted. It's already been accepted by the body. So the motion is to place it in the voting file?
That would be fine if you're satisfied with that. I move to place it in the voting file.
And no objections to the
No objections, and you want to go ahead to speak on it, or you just want to go ahead and send it down to the voting? Okay, send it down to the voting file then without any objections.
No objections.
So ordered. We have resolution now 196, and that's Senator Guthertz. Also, you are recognized. And this is substituted now. Okay, here.
First one says 272.
You want to accept Resolution 196 as substituted by the author? Okay, on that motion, without objection, so ordered. Would now a motion to place? Third reading. You may proceed then to speak.
You want to turn your mic on, Judy? Your mic's not on.
The resolution is relative to expressing the opposition to the proposal of the United States federal government's decision or plan to designate the Marianas Trench as a national marine monument. And to my colleagues, I've also passed out at this time a copy of a letter that was sent by the First Lady of the Northern Marianas, First Lady Filial, to to Mrs. Laura Bush, the First Lady of the United States. I have been in communication with the Governor's Office in the Northern Marianas as well as the Legislature in the Northern Marianas, and they've taken a position against the monument because of the impact on the CNMI. In addition, if you've been following the discussions and the media reports, and you've been visited by members of the Guam Fishermen's Co-op and other groups, the monument proposed will have an impact on Guam, and it will particularly affect our southern banks, which is a traditional fishing area for Guam fishermen. Now, currently, Madam Speaker, the Western Pacific Fisheries Management Council and the National Marine Fisheries Service have responsibilities with reference to monitoring fisheries and the use of marine resources within U.S. areas, U.S. waters in the Western Pacific. And they've done a pretty decent job. What the proposed monument would do would be to remove their current authorities over these areas. In the past, I've had the opportunity to work with the National Marine Fisheries Service and the Western Pacific Fisheries Management Council. And the council in particular has always been very sensitive to the traditions and cultures of the Western Pacific with reference to fishing practices and marine resources. I'm strongly recommending, Madam Speaker, that we pass this resolution as soon as possible in order to register our concerns with the Office of the President and other federal offices that are proposing this monument. It is my understanding that they plan to make a decision within the next 7 days regarding this matter. I've also included copies of the Joint Senate resolution of the Northern Marianas that was sent to the President of the United States on behalf of the people of Northern Marianas, and also the resolution of the Carolinian Affairs Advisory Committee that was also sent to the President and to other federal offices. So our actions would be similar to theirs, but would represent the concerns that our fishermen have and our community has here regarding this proposal. Thank you very much. I move that it go to third reading.
On the motion to place then Resolution 196 into the voting file without any objections, so ordered. Are we ready with the committee report for 340? Not yet. So Bill 227.
Madam Speaker,
Senator Speaker, you recognize.
I move to place Bill 227 back to the committee.
On the motion to refer Bill 227 to the committee, are there any objections? Without objection, so ordered.
Bill 359.
We are in Bill 359.
There's no committee report for Bill 359,
Okay, and then
so we'll skip that. They're getting it out. And so the next
Okay.
bill is 331. There is a committee
So Bill
report.
331, there is a committee report.
I'll move that. Madam Speaker.
Okay, Senator Tenorio, you're recognized.
Madam Speaker, if there's no objection, I'll move this on behalf, as the Chair of the Committee on Criminal Justice, Public Safety, and Youth, the Bill number 331 be placed in the third reading file.
On the motion without objection, so ordered. Okay, Bill 148.
Madam Speaker.
Senator Tenorio, you're recognized.
Madam Speaker, I move also to place Bill number 148 EC in the third reading file.
On the motion without any objection, so ordered. Bill 263.
Madam Speaker.
Senator Tenorio, you are recognized.
Madam Speaker, I also place Bill number, as you were, I move to place, to accept Bill number 263 as amended by the author.
On the motion to accept without any objection, so ordered.
Madam Speaker, I move to place Bill number 263 EC as amended and substituted by the author in the third reading.
On the motion then, on the motion without any objections, so ordered. Okay, I've exhausted the bills in my folder.
There's no committee report.
I don't
Madam Speaker.
have 224.
There's no
Madam Speaker, I'm waiting for the,
No committee report and no bill.
all right, so I move to refer Bill number 224 back to committee.
Okay, on the
I'm
motion.
sure you're very happy
then to
about that.
refer- On the motion to refer 224 back to the committee, then without any objection. So ordered. Thank you very much. We're going to take a
Oh, here it is, we have a bill.
reset.
375? It's being circulated. Bill 375? Okay. It's
I
here.
don't have a copy, I'm sorry.
Sergeant at Arms?
Bill 375, Senator Calvo, you are recognized.
Yeah, thank you very much, Madam Speaker. Madam Speaker, I move to place Bill 375 EC.
You want to accept as
To accept and to be substituted by the author.
On the
and to be
motion
placed-
then to accept Bill 375 without any objections ordered for,
And again, I'd like
place.
to make a motion to place it to the third reading.
and would you like to discuss it or you just?
Very quickly, Madam Speaker, what this bill attempts to do is following along in the policies this legislature set forth on the Board of Accountancy to allow them the opportunity to use the resources that are garnered through their activities for the operations of the Guam Board of Accountancy. There is a particular issue here because in talking with the compiler of laws, there were some inconsistencies in the statutes in the Guam Code that were basically contradictory in nature. So what this bill would attempt to do is to bring into harmony the sentiment of the body in allowing the Board of Accountancy to use the resources given that it earns to provide its needed services, and then at the same time to correct language that was in conflict with the spirit of legislation enacted into law in earlier years. So again, Madam Speaker, I'm asking that the legislature and my members of the body please pass Bill 375.
So, yes, as Senator Shimizu, you are recognized on Bill.
Thank you. I stand in
375.
support, and I just wanted to make sure that this legislation or the Guam Board of Accountancy, they're not tied into the allotment releases. This goes directly into their own account.
Yes.
Yeah, they take the fees and put it into their own bank. BBMR doesn't come in there and say, we're not going to release any money. I just want to make sure that doesn't happen. So this bill just says, yeah, you can use your own money, but it doesn't flow to the general government's accounting procedures of the allotment releases. I want to just make that at least redundantly clear. Thank you.
You're welcome.
Actually,
Senator
yeah,
Calvo.
thank you very much, and Madam Speaker, that was the conflict. There has been a desire by the legislature in legislation enacted into law to allow the Guam Board of Accountancy to use their proceeds of the collections for operations, and then at the same time there was not a correction in earlier statutes that basically reverted funds collected into the general fund if not used within a year. So we are deleting that particular provision and ensuring that the fund does not revert to the general fund. And then, of course, you look at the language in the substitute bill, allows them to submit a budget by a certain period to the legislature. And of course, if it's not acted upon, then the budget that was passed for the previous year will be automatically accepted. And again, that is the language in the substitute bill.
I need to take a moment recess.
got personal. She's asking, can we do the museums hotel bill surcharge? I said, we're doing bills or not. Can we do my museum bill? I support that, but I said we're doing non-controversial bills right now. But
That's a good attempt, girl. You might need to cut that a little lower.
no, done with that already.
You might need to cut that a little lower. No, this. Cut this to make it not controversial. The market picks it up.
Senator Tina, he has an amendment. Apply to the 3-hour hotels.
And then if you're using the parking spaces again, shopping center, charge it.
And also, all access drivers shall be using the off events.
Hey, you know what, you hear what my funding source was for the new landfill? Take the GRT from the revenues of the Guatali landfill and use that to fund the new landfill.
Holy sh!
It's kind of hard to type though.
How much is it?
$70. Plus like six something cheaper, $4.95 shipping.
But you realize the timing of it. Because the hotel.
I know, but it's supposed to.
And the market just fell to the floor.
Yeah, that's the only issue is the timing. Is at the time when the thing is
Didn't the market close below 8,000? The market closed below 8,000.
The Asian market?
Yes, but it's because investors are silent. The market, the prices are down, but the volume on the trading floor is also very low. So you're not having, there's a lot of people not selling or buying. So what you're looking at, it's normally when you have volume like 700,000 shares trading hands. Relative to that, we're looking at maybe 300,000 shares. And the thing is that the lower the volume is, the lower prices are, the lower oil is. So that really kind of benefits us. What else benefits us is that the Japanese yen is really, really appreciating against the dollar. So when they spend money here, it goes a lot further. I mean, it's down below 100 now. So when they come here, their money is going away. Well, the peso's it's depreciating now. Yesterday it was up at over 50. It was over 50 yesterday. When I got it, the first thing I do in the morning is to check the market reports. The second thing I do is check the exchange rate of the peso because my girlfriend lives there. So, and I got to figure out, how much money am I going to send her today, right? And I said, 50 to 1. She goes, I only saw one though, and it was slightly different from that, but I think it's the same manufacturer, different model.
I got it.
But I tell you what, it helps. I want to get the one that just folds right in half. But you know what? Yeah. The only thing is that the one that folds right in half costs almost as much as the computer. It's over $100. The one that rolls or folds? Folds over. Yeah, I saw that. That's pretty cool.
A printer for the BlackBerry.
Is it really? Really?
I read it in the PC Magazine.
Wow. Mark Doherty is at the office getting the report.
What? Who?
Mark Doherty is at his office getting the report.
Let's do it. What?
There's no test.
No. It's gonna take two. You know what? Okay, Bray, here. In deference to the incoming rules committee, could you let me objectively look at that? No, but I don't. I have a problem with us passing a bill to organize our house. What did the governor do?
Okay. The legislature is back in session. Senator Ben Pangilinan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to present the following amendment on your behalf, and that would be to amend Section 20 of Chapter 7 of Public Law 29113, and it's the authorization for prior year obligations. In the budget bill, of course, we had required that the expenditure shall be proposed no less than 45 days before the expenditure, and sometimes that's a little bit too long, and so we wanted to cooperate a little bit with the governor and give him some a little bit more flexibility, and so that it would be a requirement of 15 days before the expenditure becomes effective. So that really gives him, some authority to manage that a little bit better in terms of the notification process, and it still provides ample time for the legislature to assert its right to approve or disapprove that.
Okay. Thank you. There being no objection to the amendment, so ordered. Thank you very much. So on the motion then to place Bill 375 as substituted to the voting file without any objections, so ordered. Senator Calvo? What's your bill? Do we have a committee report?
On the land, IHA, that is
Do we
being,
have? Oh, it's being.
it is being made right now.
Okay, so we will be in recess then until we get the copies of the bills.
For about 5 more hours, Judy.
Really?
Yes. No? No. You can't leave anyway, it's too late. Too late. You should leave after 7 o'clock in the evening.
Look at this. He's telling her not to eat it all too late.
I mean,
You've been very mean to her, Gigi. I have to intervene here and say that for the record.
Because I'm trying to be her conscience in trying to get it to 30 pounds, not just 20.
So we said every week, he knows.
Hot dogs.
the legislature is back in session. As Senator Calvo, you're recognized on Bill 369.
Yeah, thank you very much, Madam Speaker. Again, thank you so much for, again, allowing for the hearing of this bill that was held down in Malolo, in particular to Bill 369. And I'd like to make a motion to place Bill 369 as amended by the committee on the,
To accept.
to accept it, and further to place into the third reading, and I'd like to discuss.
On the motion then to accept Bill 369 as amended by the committee. No objections, so ordered. On the motion to place on third reading, Senator Calvo.
Yeah, thank you very much, Madam Speaker. Madam Speaker, again, the Land for the Landless program was, again, a very, very well-intended program and a successful program. But some of the problems that occurred in the awarding of properties, and I think a lot of them were done through maps rather than the original surveys done. And in the case of 44 families that were awarded properties in the Iha subdivision, it was determined, again, upon physical inspection and surveying, that they were deemed undevelopable. And it's the intent of this particular piece of legislation that suitable land under the Chamorro Land Trust inventory be exchanged for 44 undevelopable lots, so the awardees are given 44 lots that they can proceed to move forward in their lives and building homes for their families. And again, it is also, there has been positive testimony put forward by members also of the Chamorro Land Trust, because again, the way this program works is there are other lots that will be available for Chamorro Land Trust that will also be subdivided and for uses for Chamorro Land Trust. So again, I'm asking for the support of the members of the body in supporting this legislation. Thank you very much, Madam Speaker.
You're welcome, Senator Calvo. Vice Speaker Shimazu, you are recognized.
Thank you very much, Madam Speaker. I rise in full support and with due diligence that we try to act on this as quickly as possible. This is the first session we've had since the time that we had this public hearing. I was there, and the people came and really implored us to act on it at the earliest possible day. So I want to commend the author of the bill, because it's a very simple thing. Land that can't be used, the intent was to give people land that they can use under the Chamorro Land Trust. This is a win-win situation, and should have been done as early as we can. If the good chair doesn't mind, I live in Iran, and I like to ask the good chair, if you wouldn't mind, I'd like to recommend that the good speaker be also added as the fourth co-sponsor on this, if there's no objection. She too lives down the road from
So
me.
on the motion without an objection, so ordered.
Well, in addition to that, having my good neighbor up there and having lived there, I'd like to also request that the author, if I didn't request it that evening because I think he had to leave, that I also be a co-sponsor to this bill. Yeah, thank you.
On the motion and without objection, so ordered.
And you know, I must quote our good majority leader, Senator Respicio, who just responded, and that's leadership, responded real quick and say, look, let's put a timeline, and that he recommended the 30-day timeline. So I like to be able to, that would compel the Chamorro Land Trust, and I understand from Joe Bora at that time, he said, yes, it's affirmative. It's something that we can do. So you know, today is the 21st of November. If we pass this and the governor signs it, and I implore the governor to sign it, that we'll be able to get this in time for the Christmas season. So of course I think the people of Malolo, it would be really something, because they have waited for over, I think, 15 years to be able to get this going, and I'm glad to be a part of this body to have made it happen. So again, I know there'll be no objections on any members here, because we're doing is the right thing. Thank you very much, Madam Speaker.
You're very welcome, Mr. Vice Speaker. Are there any other speakers on the bill or on the motion? Without any objections, then the bill would go down to to the voting file. I already sent it down. I asked if there are any. Okay, so notwithstanding then.
Madam Speaker, and I think it's technical in nature because I do know that
if it's technical, is it something that legal counsel can address?
Yeah, and it has to do with the sponsorship. It noted the names in the order that was placed in the original bill, and then I note on the bill that was amended by the committee, there was an omission of one name, and so I just would she could make that correct if the legal counsel could make the correction.
Well, when you say name, meaning a name of sponsor and a name of one of the landowners?
No, that's correct. On the sponsorship
okay, then
of the bill.
that's technical.
Okay.
Please take it to legal counsel then.
And that would be Senator Frank Blas's fourth sponsor.
Yeah, that's technical.
I'm flabbergasted. We still don't have any other bills then with committee reports yet?
We're just waiting for one more page on 340.
Okay. So we'll go ahead and take a brief recess then.
One more, that 256, the name for Agigi, the committee report was about in the library.
Tom. Yeah, it's already ready.
I don't know, did you finish your committee report?
Yeah, it's there. Let me get it up. Let me get it up.
Honest to God. No, I don't have it. No, I'm just...
Okay, be back in 9:30. Be back.
I want Richard to.
9:30 tomorrow.
See, I already have it on my contact.
Thank you very
Legislature's
much.
back in sessions. Speaker Ben, you're recognized on Bill 340.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to move that Bill number 340 EC as amended by the author be accepted. It was in the committee report.
On the motion without objection, so ordered.
Thank you very much, Madam Speaker. Madam Speaker, I'd like to move Bill number 340 as amended by the author into the third reading file.
Would you like to
Yes,
speak on it and explain it?
Just very briefly, Madam Speaker, Bill 340 would bring all of the health insurance programs that offer refunds and rebates into compliance with HIPAA requirements. Right now, the rebates and refunds can be tied to the utilization of health services. And under the HIPAA Act, which was finalized, the final rules and regs adopted in July of 2007, they didn't want to have anybody be discouraged from going to see the doctor because they want to have a rebate or a refund of their premium. Mm-hmm. So that was changed, and it focused on wellness programs and the participation in wellness programs. And in addition to that, participation in wellness programs, and that it can't be tied to pre-existing conditions and other conditions in qualifying for these refunds and rebates and so forth. So the law the bill as proposed removes this utilization so that there's no barrier to seeking health care and refunds and rebates. Programs that offer them and the health insurance companies that offer them must comply with HIPAA requirements in terms of wellness programs that qualify an insurance product for a rebate, and that it has to comply with those requirements, so that there is no barrier to seeking health care because of the desire to have a refund or a rebate. It also just provides an approval process for health insurance forms and health insurance products by the insurance commissioner, and it would require that they approve it within 45 days or extend it for another 45 days if they need to do so. And so I'd like to ask my colleagues, Madam Speaker, to support the bill and move it to, of course, place in the third reading file.
On the motion and to place on the voting file. No objections or we've exhausted the bills on the second reading. We're going to take a dinner break, and I ask that while the clerks are engrossing the bills, that we come back, all the members come back at 9:30 to vote. Okay, so we're in a recess until such time, 9:30.
Judy, let's go eat.
Back in session. Senator Respicio, you are recognized.
Thank you very much, Madam Speaker. Madam Speaker, notwithstanding the House rules, I move that we revert back to motions for purposes of placing some legislative confirmations in the voting file.
On the motion, without any objections, so ordered.
Thank you very much, Madam Speaker. Madam Speaker, you are in receipt of several committee reports regarding legislative confirmations, and at this time I make the following motions to place these nominations into the consent calendar, beginning with from the Committee on Education, General and Omnibus Affairs, on the nominations of Ms. Catherine M. Regis, Dr. John S. Sanchez, Ms. Ruby Stonnecker, I didn't want to mispronounce that, Miss Margie Ann L.G. Artero, Miss Roberta M. Abadai, all as members of the Guam Commission for Educator Certification with a recommendation to do confirm.
On the motion, without objection, so ordered.
Thank you. From the Committee on Tourism, Military Affairs, Veterans, and Foreign Affairs, on the reappointment of Ms. Giovanna S.A. Lujan as a member of the Port Authority of Guam Board with a recommendation to do confirm.
On the motion, without any objection, so ordered.
From the Committee on Judiciary, Natural Resources, Infrastructure, and Cultural Affairs, on the reappointment of Mr. Alfred K.Y. Lam as a member of the Guam Environmental Protection Agency Board with a recommendation to do confirm.
On the motion, without any objection, so ordered.
We also have from the Committee on Judiciary, Natural Resources, Infrastructure, and Cultural Affairs on the nomination of Mr. Ronald M. Young to serve on the Guam Environmental Protection Agency Board, and this committee also recommends its confirmation.
On the motion, without any objection, so ordered.
Another motion, Madam Speaker, is I move that resolution number 199 and substitute resolution number 196, substitute bill number 331, and substitute bill number 148, and bill number 263 be voted on without engrossment.
On the motion, without any objection, so ordered.
No, Madam Speaker, notwithstanding the House rules, I move that we go to the consent calendar.
Legislative calendar. On the motion to go to
No, but that's
consent. Consent calendar.
Thank
Your
you.
motion, what's your motion again?
legislative concurrence calendar, I'm sorry. Yeah. So on the legislative concurrence calendar, Madam Speaker, that motion I just made for all those nominees, I move that they all be placed in the voting file.
On that motion, then, without any objections, so ordered. Senator Respicio?
We did. For civil service? For what? For civil service? Yeah, I just did your mind. Madam Speaker, on bill number 383, I don't think I need to make a motion, but for purposes of discussion on page 3, line 23, the amendment that was offered had a period after the word landfill.
What page again?
Page 3.
Page 3.
Line 23. After landfill, it should be a period because the mover of this amendment did not offer this amendment as is being presented in the engrossed version of Bill 383. So if the body agrees that
Well,
yeah, that's what I'm just
let me
offering
check with
as a
legal
point of
counsel.
information.
I'll give it 1 minute and we'll go check with the
Yeah,
clerks.
'cause if
Thank you.
someone need a motion, then I'll do it, but it's. We deleted it, yeah. But it's still in the. No, I understand. No, I'm saying, yeah, it was amended, it wasn't here, but I guess the email was on the Lester, you moved this without this language, right?
Yes.
How did
And then I think what happened is when I sent Flo
It was another
electronic, it was the one before. I sent you the wrong one. I didn't have that thing on. That's my mistake.
So you want to put a period
I didn't make a motion, but they agreed to but Lester sent an earlier version. No, they didn't send it. So what
using the recycling paper. And then, you know that if you use it right, you can shred it, and it becomes, and you can mulch, shred food.
So let me just move.
I should bring the shredder.
Any other, all the other bills okay? Is that again, confirmations?
Especially the elementary, because they use the back for their art classes. They use it, for paper mache and all those things. Yeah, that's good.
The legislature is back in session. Senator Respicio.
Thank you, Madam Speaker, for your decision that the concern I raised was a technical amendment and it'll be addressed. Notwithstanding the House rules, I move that we go to the voting file for purposes of voting.
Okay, we're in the voting file. Okay, the first bill that we have is bill number 383. I'd like to ask the clerk if she could read the bill.
Bill number 383 LS as amended in the Committee of the Whole, introduced by the Committee on Calendar by request of Imagalayan Guam, the Governor of Guam, in accordance with the Organic Act of Guam. An act to amend section 1512.1 and to add a new section 1512.2 to Title V Guam Code annotated relative to the financing of a new landfill, to amend sections 51504, 51507, and 51508 of Title X Guam Code annotated relative to recycling, to permit use of Lot 439-R1 Santa Rita as a sanitary landfill, to amend section 2104 of Title I Guam Code annotated relative to the Commission on Decolonization, to amend section 75102 of Title 21 Guam Code annotated relative to the Chamorro Land Trust Commission, and to amend section 8 of Public Law 29-82 relative to the Guam Power Authority loan.
Roll call.
Senator Blas. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Gutherds.
Yes.
Senator Shijaki.
Pass.
Senator Lohan. Senator Muna Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio.
Yes.
Senator Shimizu. Senator Tenorio. Speaker Wampat.
Yes.
Senator Blas. Senator Benjamin Cruz. Senator Shijaki. Senator Lohan. Senator Tenorio. Senator Shijaki. Senator Lohan. Senator Tenorio.
Bill 383 LS received 9 yeas, 4 nays, 2 absent. Senator Tenorio?
Madam Speaker, I move to excuse Senator Jim Espadon and Speaker Forbes.
Okay, on that motion, without any objection, so ordered. So therefore, Bill number 383 LS is duly passed. Bill number 297. Roll call.
Speaker Pangilinan. Senator Respicio. Senator Shimizu. Senator Tenorio. Speaker Wampa.
Yes.
Let's clap for his first bill.
Another 28 legislature, guys.
Substitute Bill 297 EC received 13 yeas and 2 excused absence. Substitute Bill number 297 EC is duly passed. Bill number 272.
Bill number 272 EC as substituted by the Committee on Education, General and Omnibus Affairs and amended on the floor. Introduced by Judith P. Gutherz, DPA, RJ Respicio, BJF Cruz. An act to add new sections 17202.1, 17202.2, and 17202.3, and to amend section 17204, all of Chapter 17 of Title III Guam Code annotated, relative to the presentation of initiative measures.
Roll call.
Senator Block. Senator Caldwell. Senator Benjamin Cruz. Senator Spadon. Speaker Forbes. Senator Gutherz. Senator Shijaki. Senator Lohan. Senator Muna Barnes. Senator Palacios. Speaker Pangilinan? Senator Respicio? Senator Shimizu? Senator Tenorio? Speaker Wampat?
Yes.
Senator Lohan?
Substitute Bill number 272 received 13 yeas and 2 excused absence. Substitute Bill number 272 is duly passed. Bill number 378.
Bill number 378 EC as amended on the floor. Introduced by R.J. Respicio, Judith P. Guthers, DPA, B.J.F. Cruz, and others. An act to add a new chapter 23 to Title I Guam Code annotated relative to creating a commission Guam. Fininitna, the Guam First Commission and on the military mission in Guam, and to amend section 2105 of Title IV Guam Code annotated relative to representation of both genders on boards and commissions.
Roll call.
Senator Blas? Senator Caldwell? Senator Benjamin Cruz? Senator Espaldon? Speaker Forbes? Senator Guthertz? Senator Sajaki? Senator Lohan? Senator Munia Barnes? Senator Palacios? Speaker Pangilinan? Senator Respicio? Senator Shimizu? Senator Tenorio? Speaker Wampat?
Yes.
Senator Shijaki? Senator Tenorio?
We are voting, so please. Yes, I know, but let him decide on his own.
Yes. Senator Shijaki?
Bill number 378 EC received 12 yeas, 1 nay, 2 excused absence. Bill number 378 is duly passed. Congratulations. Bill number 377.
Bill number 377 EC, introduced by V.C. Pangilinan. An act to authorize Magalang Guahan to pledge compact impact funds for the construction cost of a new landfill.
Roll call.
Senator Blas? Senator Caldwell? Senator Benjamin Cruz? Senator Spaldon? Speaker Forbes? Senator Guthertz? Senator Sajaki? Senator Lohan? Senator Munia Barnes? Senator Palacios? Speaker Pangilinan? Senator Respicio? Senator Shimizu? Senator Tenorio? Speaker Wampat?
Yes.
Senator Blas? Senator Benjamin Cruz. Senator Shijaki. Senator Lohan. Senator Respicio. Senator Bloss. Senator Benjamin Cruz. Senator Shijaki. Senator Lohan. Senator Respicio.
Bill number 377, EC, received 8 yeas, 5 nays, 2 excused absence. Bill 377 is duly passed. Resolution number 199.
Resolution number 199 LS, introduced by J.P. Guthers, R.J. Respicio, B.J.F. Cruz, relative to endorsing the strategic development plan for the establishment of the Micronesian Center for a Sustainable Future and an administrative research and development center for the Micronesian Chief Executives Summit and the Micronesian President's Summit.
Madam Speaker, if there's no objections, I move that we vote on these 2 resolutions by show of hands.
Okay, on that motion, without any objection, then, so ordered. So all those in favor then of resolution number 199, please raise your hands. She just did. No, we're in resolution 199. This was the motion that was made, 2 resolutions and other bills are not engrossed. No, you had it separate, yes.
Can you help them keep their hands up?
So please keep your hands up. All those in favor, please raise your hands.
2, 4, 5, unanimous.
Okay. Resolution number 199 received unanimous support, so it's duly passed. Resolution number 196, can you read the title of the resolution? Clerks, 196.
Resolution number 196 EC, as substituted by the author, introduced by J.P. Guthers, R.J. Respicio, B.J.F. Cruz, relative to expressing opposition to the proposal of the United States federal government to designate the Marianas Trench as a national marine monument.
All those in favor, please raise your right hand. Okay. Keep your hands up. Okay. Resolution number 196 received 14 yeas, so it's duly passed. I'm sorry, not 14 because we're minus 3, so 12. Yeah, because. No, -2, but one didn't vote also, so therefore, so it is 12. You want to count in, clerk? Do you mind counting then again? Please raise your hands. And so 12 votes, it received 12 votes, so it's duly passed. Bill number 331. Remember, this is the one that's not engrossed because there were no amendments to it, so it should be in your packet. Can you read the bill, please?
Bill number 331 LS, a substitute for the Committee on Public Safety, Criminal Justice, and Youth, introduced by F.T. Shizaki, Arthur Respicio, A.B. Palacios, Sr. An act to add a new section 3218 to Chapter 3, Article 2, Title 16, Guam Code annotated relative to the prohibition of the sale of tires aged over 6 years, the stating of the date of manufacture, and the mandatory posting of the dangers of aged tires at the point of sale.
Roll call. It should be in your other, in your second reading file. Yes, because there were no amendments to it, so it's not engrossed. Okay, so roll call. No. Okay.
Senator Bloss. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Gutherts.
Yes.
Senator Shijaki. Senator Lohan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu.
Yes.
Senator Tenorio. Speaker Wampat.
Yes. Bill number 331 LS received 13 yeas and 2 excused absence. Substitute bill number 331 is duly passed. Bill number 148 is also the same, it's not engrossed. Please check in your second reading file folder. Can the clerk please read the title?
Bill number
148.
Bill number 148 EC, a substitute by the Committee on Criminal Justice, Public Safety, and Youth, introduced by Ray Tenorio, E.J.B. Cabu, F.T. Shizaki. An act to add a new Chapter 91-2 and a new Section 80.70 to Chapter 80 of AGCA relative to vulnerable witness testimony.
Roll call.
Senator Bloss. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Gutherts. Senator Shijaki. Senator Lohan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu.
Yes.
Senator Tenorio. Speaker Wampat.
Yes. Substitute bill number 148 EC received 13 yeas, 2 absent. Substitute bill number 148 is duly passed. Bill number 375.
No.
Okay, bill number 263.
Bill number 263 EC, as amended by the author, introduced by Ray Tenorio, J.T. Wampa, J.P. Guthertz. An act to add a new section 19107 to Chapter 19 of 16 GCA relative to the presentation of insurance documents to establish proof of insurance.
Roll call.
Senator Blas. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Guthertz. Senator Shijaki. Senator Lujan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu. Senator Tenorio. Speaker Wampet.
Yes.
Speaker Pangilinan. Speaker Pangilinan.
Bill number 263 received 13 yeas and 2 excused absence. Bill number 263 is duly passed. Bill number 375.
Bill number 375 EC as substituted by the author, introduced by Edward J. B. Calvo. An act to amend subsection D of section 35104 of Title 22 of the Guam Code annotated relative to the Guam Board of Accountancy.
Roll call.
Senator Blas. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Guthertz. Senator Shijaki. Senator Lujan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu. Senator Tenorio. Speaker Wampet.
Yes. Substitute Bill number 375 EC received 13 yeas and 2 excused absence. Substitute Bill number 375 is duly passed. Bill number 369.
Bill number 369 LS as amended by the Committee on Education, General and Omnibus Affairs and amended on the floor. Introduced by E. J. B. Calvo, R. J. Respicio, Tina Rose Munya Barnes, and others. An act to exchange lots within the EHA subdivision, land for the landless project, with other lots in Inarahan.
Roll call.
Senator Blas. Senator Calvo. Senator Benjamin Cruz. Senator Spaldon. Speaker Forbes. Senator Guthertz. Senator Shijaki. Senator Lujan. Senator Munya Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimizu. Senator Tenorio. Speaker Wampet.
Yes. Bill number 369 LS received 13 yeas and 2 excused absences. Bill number 369 is duly passed. Bill number 340.
Bill number 340 EC as amended by the author, introduced by V.C. Pangilinan. An act to repeal and reenact Section 15707 and to amend Sections 18308 and 18501A of Title 22 Guam Code Annotated and to add a new Section 15707.1, 18308.1, and 18501.1 to Title 22 Guam Code Annotated to clarify the law on health insurance refunds or rebates consistent with the final rules for non-discrimination and wellness programs issued December 13, 2006 under the Federal Health Insurance Portability and Accountability Act of 1996, HIPPA, as amended, and to provide for a time frame for insurance rate and form review.
Roll call.
Senator Blas. Senator Calvo.
Madam Speaker, I move to again allow the body to request the body to allow me to recuse myself in voting on this bill for a potential conflict of interest.
Should the body excuse, then allow the recusement of Senator Calvo? Please indicate no objections. Okay, so ordered. You're excused.
Senator Benjamin Cruz. Aye. Senator Spaldon. Speaker Forbes. Senator Gutherts.
Yes.
Senator Sujaki.
No.
Senator Lohan.
No.
Senator Munya Barnes. Senator Palacios.
None.
Speaker Pangilinan.
Okay.
Senator Respicio.
Yes.
Senator Shimizu.
Yes.
Senator Tenorio. Speaker Wampat.
Yes.
Senator Blas. Senator Tenorio. Senator Blas. Senator Blas.
Yes.
Bill number 340 EC received 9 yeas, 3 nays, and 1 excused, recused from voting, and 2 excused absences. So bill number 340 is duly passed. On the matter of the nomination of Ms. Naomi Eve Lujan Gonzalez to serve as Executive Director of the Civil Service Commission.
Did we do the 263?
Roll call.
Madam Speaker? If there's no objections, I move that these nominees be voted by show of hands, but individually.
But in this
Is it-
particular case, is the
Oh, the Executive Director, I'm
Director.
sorry, I thought it was for the boards and commissions.
Yes, okay, for the other
With the
boards and
exception of the
commissions.
Executive Director.
Okay, so roll call for the Director, Executive Director. Roll call.
Senator Blas.
Yes.
Senator Calvo.
Aye.
Senator Cruz.
Aye.
Senator Spaldon. Speaker Forbes. Senator Gutherts.
Aye.
Senator Shizaki.
Yes.
Senator Lujan. Senator Munia Barnes. Senator Palacios. Speaker Pangilinan. Senator Respicio. Senator Shimasu. Senator Tenorio. Speaker Wampen.
Yes. On the appointment of Ms. Naomi Eve Lujan Gonzalez to be the Executive Director of the Civil Service Commission, the votes are 13 yeas and 2 excused absence. Ms. Lujan Gonzalez is duly confirmed by the 29th Guam Legislature. Yes. So I'm going to have the clerk read each one of them, and it will just be a show of hands.
On the appointment of Ms. Catherine M. Reyes to serve as a member of the Guam Commission for Educator Certification.
All those in favor, please raise your hands. Okay. Ms. Catherine Reyes then received unanimous support. She is duly confirmed.
On the appointment of Dr. John S. Sanchez to serve as a member of the Guam Commission for Educator Certification.
All those in favor, please raise your right hand. Dr. John Sanchez received unanimous support. He is duly confirmed by the legislature.
On the appointment of Ms. Ruby Staunecker to serve as a member of the Guam Commission for Educator Certification.
All in favor, please raise your hands. Ms. Ruby Staunecker is received unanimous support. She is duly confirmed by the legislature.
On the appointment of Ms. Margie Ann L.G. Artero to serve as a member of the Guam Commission for Educator Certification.
All those in favor, please raise your right hand. Okay. Ms. Margie Ann Artero is received unanimous support. She is duly confirmed by the legislature.
On the appointment of Ms. Roberta M. Abade to serve as a member of the Guam Commission for Educator Certification.
All those in favor, please raise your hands. Ms. Roberta Abadai has received unanimous support. She is duly confirmed by this legislature.
On the nomination of Ms. Jovina S. A. Lujan to serve as a member of the Port Authority of Guam Board.
All those in favor, please raise your hands. Ms. Jovina S. A. Lujan has received unanimous support. She is duly confirmed by this legislature.
On the appointment of Mr. Alfred K. Y. Lam to serve as a member of the Guam Environmental Protection Agency Board.
All in favor, please raise your right hand. Mr. Alfred Lam has received unanimous support. He is duly confirmed by this legislature.
On the appointment of Mr. Ronald M. Young to serve as a member of the Guam Environmental Protection Agency Board.
All those in favor, please raise your hands. Mr. Ronald Young received unanimous support. He is duly confirmed by this legislature. I believe we've exhausted and everything in the voting file. Senator Respicio, Tenorio.
Are we in brief extension remarks, Madam Speaker?
Okay, we'll take a brief.
I know it's very late, and I just wanted to say to all of you and all the people of Guam, Happy Thanksgiving.
Okay. Thank you very much, Senator Respicio.
Thank you. I move to adjourn, subject to the call of the Speaker.
On the motion, without any objection, so ordered. Happy Thanksgiving, everybody.
Safe trip, buddy.